All right, good morning and welcome to the Nevada State Board of Pharmacy June 2026 meeting. Today is Wednesday, June 3rd, and our meeting will now come to order. My name is Helen Park and I'll be the presiding officer. We'll start with the Board of Pharmacy mission statement. In regulating the practice of pharmacy, the Nevada State Board of Pharmacy has a duty to carry out and enforce the provisions of Nevada law to protect the health, safety, and welfare of the public. Next, we'll do our roll call. Mr. Adam Porath.
Here.
Ms. Shanice Taylor.
Present.
Ms. Crystal Freitas.
Here.
Mr. Richard Tomaso.
He has an excused absence.
Okay, I thought I saw him online.
If he is, he's not supposed to be. He's actually under the weather and we're trying to get him. But he will be in today. I'll make it a mention. I don't think he's here yet though.
Okay, and then Miss Anna Carr.
Present.
Okay, and then do we have Miss Jade Jacobo?
Present.
Okay, we have a quorum present. Mr. Weiss, any announcements?
Good morning, Madam President. A few announcements. The meeting will be held under Nevada open meeting law. Also components of it will take place on Zoom. For the public, if anybody's on Zoom, you'll see them to the left. The board knows where to look. And for the people at home that are on Zoom, you can change your gallery view however you want. We will have a quorum throughout the meeting today. The staff will be monitoring it. We have some excused absences, so people will be coming on and off. I'll remind the board members to notify us when you're on and when you have to leave. We do have some people that have served the board in the past. So we have Jody Lewis. Thanks for your service in the past and thanks for being here. Melissa Shake, thank you too. And then we do have the most recent past president of NEBP in the corner over there, Brad Hamilton. He is from Maine. I didn't know that people from Maine came to Nevada without a Taylor Swift concert. I guess that this was a special exception. So welcome to the board meeting today. And with that, Madam President, I'll turn it back over to you.
Great, thank you, Mr. Weiss, for your announcements. As our next order of business, the board will open up the floor for any public comment. If we have anyone in the room or online who wishes to make a public comment, we ask that you please come forward. As a friendly reminder, public comment may be limited to 3 minutes per person. Do we have anyone in the room who wishes to make a public comment? All right, do we have anyone online who wishes to make a public comment? If so, please let us know through the chat function or raise your hand or press *9 or *6 to have your line unmuted.
Not seeing anyone, Madam President.
All right, so we'll close the period for public comment for now. There will be another opportunity at the end of the day. Next, we will do the approval of the meeting minutes from the April 2026 meeting. Board members, any discussion on the meeting minutes? I had a chance to review. I don't have any questions or concerns. I feel comfortable moving forward with the minutes.
Crystal Curtis, I agree, so I will to approve the board meeting minutes from April 15 through 16, 2026.
Okay, we have a motion by Ms. Freitas, a second by Mr. Porath. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? Okay, the meeting minutes have now been approved. Next, we have the consent agenda.
Madam President, Dave Weiss for the record. I have just one request, item number 47, AAA Daniel Chow. I just need to do a little bit more backup information on that. So I'll have somebody at the board office do that. So if you can, you have an opportunity to move forward, but we'll just tell you what that's about. And if you can just not vote on that now, I appreciate it. It gives us a little time.
Certainly, thank you. And thank you for that catch, Mr. Weiss.
Thank you for the catch.
All right. Any questions on the consent agenda? Daniel Chow or 4.7 was the only question that came up. Everything else looks in order to me.
I agree, Madam President. I move that we approve the consent agenda with the exception of item 4AAA, Daniel Chow.
Second.
Okay, we have a motion by Mr. Porath, a second by Ms. Taylor. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? All All right, with that, the consent agenda is now approved and we will move on to our regular agenda. So we'll start with agenda item 5C, and that is for Antonio Gumina. So Dr. Gumina or representatives, if you could please come forward.
Brett, have you been in contact with them recently? 5C, have you talked to 5C recently?
Brett Campbell, the record, prosecutors met on behalf of the case, which is case number 24-430 CSS. Responding to Antonio Gumina, MD, certificate of registration number CS 09380. It was my understanding that Dr. Gumina would be making at least a video appearance today because we have a stipulation to present your consideration of possible approval. So I don't know what to.
Give him a minute, doctor, if you're on the line, if you're on Zoom, if you can hit the raise hand button to identify yourself. Yeah, if you just go to the next item, I'll have somebody reach out to him.
All right, so we'll move on to agenda item 5E for Hilco Vision. So if we have representatives, please come forward for Hilco. Hi, good morning, Mr. Moore.
Morning.
Will anyone else be joining you today?
CEO of the company is supposed to be on Zoom.
Okay, so we'll wait for the CEO. What is his name?
So-
Oh, here he is. All right.
I'm not the CEO. I'm the VP of Global QARA.
Okay, thank you for that. And then, Mr. Moore, are you here representing as the attorney or as a representative of the company?
As an attorney.
As an attorney, and you are barred in Nevada?
Well, I've talked with Brett.
Brett Campbell, the record. Counsel from out of state routinely appear before the board on stipulations. So to clarify, there's not an evidentiary hearing anticipated today. Rather, we're appearing to present for your consideration a stipulation to resolve the matter.
Senior Dag Todd Weiss, that's fine. And no, we don't need to, he's still an attorney. We don't need to swear him in.
Okay. All right, so with that, then for Mr. Hufnagel, I'm going to swear you in. You could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great, thank you. Okay, Mr. Cant.
Once again, Brett Kent, prosecutors matter on behalf of the state, case number 28-187 WHS, the Hillsinger Parent Company Parent LLC, DBA Hilco Vision, wholesale license number WH02862. The charging document appears beginning on page 2300 of the board book. We do have a stipulation present for your consideration this morning. That begins on page 2310. So by way of brief background, the allegations, the basis for the charges are that on or about October 2nd of 2024, the FDA issued a warning letter regarding manufacture of certain products in India, determining that some of those products did not conform to current good manufacturing practices and thus were adulterated and should also were manufactured in a facility that was not registered with the FDA and thus misbranded, and then were prohibited from interstate commerce. And the respondent engaged in the sale or distribution of some of those products into Nevada on 26 occasions after the FDA issued that warning letter. So that's the conduct that gave rise to the charges. Do want to note that on or about December 4th, 2025, the respondent submitted a closure notice to the board and effectively surrendered their license number WH02862. So in order to resolve the matter, the respondent would stipulate to payment of a $2,500 fine due and payable by July 1st and $1,000 to partially reimburse the board for recoverable attorney's fees and costs, also due and payable by July 1st. This is the stipulation we've got for your consideration.
Great. All right, with that, I'll turn it over to Mr. Moore for any additional comments or remarks.
I would like to refer to the CEO or his title, let him make some remarks, and then I'll close it out,
Certainly,
if that's okay.
of course, yes.
Yeah, so we definitely treat this incident very seriously. We've, as you mentioned, closed the facility. We do have another facility in Fairfield that we operate, which had not sold any of the product into Nevada. We've, since the incident became apparent, let go of the person that approved the sales. And we've also strengthened our quality system quite a bit to avoid any recurrence of this happening in the future, along with scouring FDA recall notices and warning letters to make sure that even if our customers don't inform us of the warning letter, that we take action in advance so that we don't repeat this offense.
Thank you for that. Just a question for you, Mr. Hufnagel. So did you close the facility based on the notices that you received from the FDA and because of the
No, that was somewhat coincidental. It was closed as part of our consolidation efforts to only use the facility in Fairfield that we operate.
Great, thank you. All right, Mr. Moore?
First, I'd just like to say I'm also a pharmacist and also a past president of NABP. And I've represented this company in some other issues among other boards. And every time we have an issue, they are very compliant with my suggestions. One of the things I'd suggest with them was assign some person to weekly look at the recall list to make sure we don't miss anything. So over the period of time that I represented them, they've been very compliant with everything that I've suggested for them. And I think that you'll see that they'll continue to do that. Thank you.
Great, thank you for that. And that's certainly good to hear. And I appreciate the nice that you're able to provide that guidance. Board members, any questions for Hilco or the stipulation?
I don't have any questions. That we approve the stipulation or Hilco Vision.
She say my second.
Yeah, we have a motion by Mr. Poroff, a second by Ms. Taylor. Any further discussion? I do feel like based on the testimony from Mr. Hufnagel, sorry, and Mr. Moore, that certainly they've taken this very seriously and have made some changes to ensure future compliance. So, right. With that, all those in favor?
Aye.
Any opposed? Okay, the motion passes. All right, thank you for your time today.
Thank you very much.
I'll get you some.
All right, next we will go to 5F for Patricia Sanchez. Patricia Sanchez, if you are here, if you could please come forward or raise your hand on Zoom.
At least for the record, Madam President, she was notified. We did receive a call from her that she didn't plan to appear, but I'm glad that you called her, and I don't see her on the Zoom call. Right here in person.
So I will turn it to Mr. Camp.
Brett Camp, the Director prosecuting this matter on behalf of the state, case number 26108 PTTN. Respondent Patricia Renee Sanchez, PTT certificate of registration PT 28814. The charges begin on page 2316 of the board book. The respondent did file an answer, which begins on page 2325 of the board book. And by way of brief background, the respondent's criminal history includes an arrest and conviction in 2001 on one count of conspiracy to violate the Uniform Controlled Substances Act, a category C felony. The respondent failed to disclose that criminal history to the board on our 2023 application for registration as pharmaceutical technician in training. was issued her certificate of registration, and she subsequently failed to disclose that criminal history on her 2025 application for registration as a pharmaceutical technician. And I will also represent that the respondent, while submitting an answer to the charges in which she acknowledges the failure to disclose, also indicated she did not intend to appear today at this hearing. So I'm prepared to proceed with the default. First, I will pass out a copy of declaration from board staff that the respondent received proper notice of the charges and the hearing today in conformance with Nevada law.
Tyler, can you assist him,
Ask
please?
that be entered into the record as exhibit 1. And just to confirm with board staff, that board members that are appearing will be provided copies of those documents. Thank you.
Okay, so admitted as exhibit 1.
And with that, I'm just prepared to just proceed to ask you to make findings of fact, use the law in their own order. So with that, I would ask first that you make findings of fact as to jurisdiction of the allegations as stated in paragraphs 1 through 3 of the accusation.
Jay Jacobo, so moved.
Carissa Hurd, second.
We have a motion by Ms. Jacobo, a second by Ms. Freitas. Any further discussion? All those in favor?
Aye.
Opposed? Okay, that motion carries.
Next, I would ask that the board make conclusions of law consistent with paragraphs 4 through 9 of the accusation, to find the respondent guilty on both counts, and also to find that the respondent was noticed of the charges in this hearing in conformance with Nevada law.
So moved.
Go ahead, Jane.
Sorry.
It's okay.
So moved.
Okay, can you just, I'm sorry, could you repeat that for the record?
Yes, Jay Jacobo, so moved.
I will second.
Okay, great, thank you. So motion by Ms. Jacobo, second by Ms. Freitas. Any further discussion? Hearing none, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes.
Next, in the instance the board is inclined to impose discipline on this respondent, I'm going to pass out a memorandum of attorney's fees and recoverable costs that the board may seek to recover pursuant to NRS 622-800. They total $1,118.15. I'd ask this be entered in the record as exhibit 2.
This isn't it.
Oh.
Oh, apologies. I've got a copy right here. The top of that pile of documents was the memo of fees and costs. I don't know if it got copied.
You just want to submit that to Helen and we'll keep it for the record? Yeah. And Helen, you can share it with the other board members. Thanks, Brett.
Great, thank you. All right, well, so admitted as exhibit 2.
And moving on to penalties, I guess I leave it to the board. The respondent failed to appear, you could revoke and for the minimum 1 year before they can petition for reinstatement, or you could take some lesser penalty. And I would also ask that you award the recovery of the attorney's fees and costs as noted on the penalty. whichever action you take, I would ask that the order be effective immediately. And that you make a finding that the attorney's fees and costs for reasonable necessary action incurred.
Okay. And I'm sorry, Mr. Cant, I might have missed the beginning of that. Could you just summarize real quick?
Yeah, once again, Brett Kemp for the record. So as to penalties, the respondents declined to appear, has withdrawn her application for registration as a pharmacy technician. So you could take the action to just revoke for the 1 year period to the 1 year statutory minimum to petition for reinstatement. Or you could impose some lesser penalty.
Or a greater penalty. I just add question here is her tech and training or tech and training. So she never got her tech license, so you're just dealing with her tech and training. Historically, you would revoke it and she can reapply at some point.
Great, thank you.
Jay Jacobo, I move that we find the attorney's fees and costs to be reasonable, necessary, and actually incurred and due in the amount of $1,118.15. Due within 30 days of this order. And I also move that we revoke pharmacy technician in training. Well, I guess she has applied for the pharmacy technician and she just is no longer pursuing that.
That's correct. I mean, I don't know, she said she was going to, the staff was kind of trying to help her through this process. She does not have a pharmacy tech in training, or she does not have a pharmacy pharmacy tech license right now. Thank you.
So I would move that we revoke Patricia Renee Sanchez's pharmacy tech and training license.
For a period of 1 year before applying for.
For a minimum period of 1 year, yes.
Brett Kemp, sorry to interrupt, just to make that clear for the record, revocation is permanent, but that the statutory minimum of 1 year before she can petition for reinstatement is what you impose.
Okay, I would like to correct my motion to reflect Attorney Brett Kant's recommendation.
Okay, and the last part being effective immediately?
Yes.
Okay, great. All right, so we have a motion. Do we have a second?
Crystal, bring that second.
We have a motion by Ms. Jacobo, second by Ms. Freitas. Any further discussion?
Yeah, Adam Porth for the record. I mean, I think this is a really good example of the situation where, I mean, that within the fence here, I mean, there's reasonable justification as to at least why I think she felt like I don't think that she was doing this deceitfully necessary. I think if she would have showed up to today, it would be different, but it's hard not
I agree.
being able to get her opinion, being able to hear from her, so it's unfortunate.
Any further discussion? All right, with that, all those in favor?
Aye.
Any opposed?
Sorry,
that
Anna
motion.
Hart, I had trouble coming off mute.
Okay, great. Thank you. Any opposed? All right, that motion passes. Thank you, Mr. Cant. All right, we'll continue with our next agenda item, 5K for Jose Escobedo. So if we have Jose Escobedo or representatives, please come forward.
Morning, Madam President. Lynn Meggs on behalf of Jose Escobedo, who's not present with me today.
Okay, great. For the record, I do want to disclose that I am familiar with Jose Escobedo during his time at Roseman University, but I feel that I could participate fairly and unbiased in this matter. Right, with that, I will turn it over to Mr. Zanino.
Thank you, President Park. For the record, Greg Zanino, handling this matter on behalf of board staff. As you indicated, this is the matter of Nevada Board of Pharmacy versus Jose Escobedo. It's case number 24424 RPH-CS. The charging document begins at page 2422. of your board book, and I would ask you to note that there are a great many respondents who were named in this case. Jose Escobedo was one of, I think, about 14 pharmacists who were named. The allegations in a nutshell are that was filling prescriptions that were unlawful or didn't comply with legal requirements under circumstances where he knew or should have known that those prescriptions did not comply with legal requirements. I think all of the respondents, except for at least the pharmacist respondents, except Respondent Escobedo requested continuances. But Respondent Escobedo was kind of anxious to get this matter behind him and take accountability for his conduct. So we've reached a stipulation, and we've drafted a stipulation of proposed order for your consideration and possible approval. That begins at page 2449 of your board book. And I will just cover the key provisions of that. And I need a moment to scroll down to it.
No.
Again, the stipulation proposed order begins at page 2449 of the board book, and I've located that, and I'll just summarize for you the allegations. Beginning at paragraph 6, respondent does not contest the allegations in count 1 of the accusation and admits that there's sufficient evidence to prove up those allegations. I summarized those
stipulation thing because of his newness and this experience where there was, 900 prescriptions that went through this way, is that I would consider that the board change the period of probation from 2 years to 5 years for Mr. Escobedo's benefit.
I don't know, I have to get in touch with my client, he's at work today, so I don't know if I'd be able to touch base with him today to see if he'd agree with that modification, if the board's inclined to do that.
I'm not sure my board members agree yet, so I think before we do that, we'll have the discussion with the board and then we'll determine. But board members, just your thoughts on potential revision to the stipulation.
Before you do that, you'll be given every chance. I think that they'll do a discussion and maybe they'll decide where they're gonna go, and then we can give you some time to do that, Ms. Beggs, if you need it.
I do agree with you in the state that being that Mr. Escobedo is a newer pharmacist, it can be a little intimidating coming into the workforce and having these senior pharmacists around him and they're all doing something that's questionable. I think this experience would stand out to him and going forward in the decisions that he makes and standing on his ground. I don't feel comfortable with extending the probation to 5 years. In that extent, being that he was at least trying to do his due diligence in the aspect of raising a question, right? I feel like as a newer pharmacist, a mistake can happen. We would not want this type of mistake to occur. However, 2 years, I feel like would be a learning example for him.
Any other thoughts or comments, board members?
Yeah, Adam, for the record, I would agree.
Adam, can you do me a favor? Just move the mic a little bit closer to you because we're getting some audio things and they want to hear what you have to say.
Sure. Adam, for the record, I would agree with board member Taylor. I do appreciate the fact that Mr. Escobedo is taking account for his actions here. So I would be inclined to leave the probation 2 years.
Okay, any other thoughts or comments? All right, then is there a motion?
Adam, board, for the record, I would move that we approve the stipulation order for Jose Escobedo as defended by board staff.
Shanice Taylor, I second that.
Okay, we have a motion by Mr. Porath, a second by Ms. Taylor. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Okay, any opposed? Nay? The ayes have it, that motion passes. Thank you for your time.
Madam President, item number 13, or sorry, 5C, Gamino, he's on the line now. A misunderstanding on his part, he'll probably explain it to you.
Okay, all right, so we'll go to agenda item 5C for Dr. Antonio Gumina. Hi, good morning. Oh, it looks like your line is unmuted or muted.
Doctor, you muted.
Good morning.
Yeah. Thank you.
Good morning, Dr. Gumina. Will anyone be joining you today?
No.
Okay, great. So I'm going to go ahead and swear you in. If you join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Okay, great. Thank you. Mr. Cant.
Brett Camp, for the record, prosecuting this matter on behalf of the state, case number 24430 CSS, respondent Antonio Gamina, MD, certificate of registration number CS 09380. The charging document begins on page 2245 of the board book. Respondent about the answer that appears on page 2255. We do have a stipulation to present for your consideration and possible approval, which begins on page 2257. I do want to note one typo in the proposed stipulation, which is on page 4 of the stipulation, or 2260 of the board book. At the very top, in paragraph 9, it inadvertently references the wrong registration number. That'll be corrected should you approve the stipulation to CS 09380. Board staff will correct that, but by way of brief background and then to detail the terms of the stipulation, the charges against the respondents stem from violations related to the prescription monitoring program database. Alleged that the respondent failed to properly query the database as required by law prior to issuing controlled substance prescriptions, permitted unauthorized persons to use his username and password to unlawfully access his practitioner account in the database. And he also failed to query and review for accuracy his MyRx prescriber activity report as required by law. So in order to resolve the matters, the respondent, he would stipulate to being placed on probation for a period of 2 years, receive a reprimand, pay a fine of $5,000 due and payable by June 3rd of next year, and pay a fine of $1,000, or excuse me, pay $1,000 to partially reimburse the board for recoverable attorney's fees and costs that would be due and payable by July 31st of this year. He would complete training with board staff on use of the PMP in compliance with Nevada law. He would complete that training within 60 days of the order and complete follow-up training within 6 months of the initial training, and while on probation, stay out of trouble. So upon successful completion of probation, his certificate of registration would be fully restored. So this is the stipulation we're presenting to your consideration.
Great. Dr. Gumina, did you want to add any additional comments or remarks?
No, I think a lot of this stemmed around the fact that during COVID, I started to use an online or on my phone app for prescribing. And it actually gives you the details of any prescriptions written over the last 14 months. And so I started to believe that if I was getting that information, I didn't need to pull the PMPs because I could see right on my device that whether prescriptions were being written by myself or somebody else. So that's kind of where the confusion went to. And the one staff member that was accessing and printing some of my PMPs at time has been with me for many, many years and does follow all the HIPAA guidelines for our office. And so I understand that she didn't have her own account and was accessing using my account. And so I pled guilty to everything and will agree with the stipulation if approved by you.
Okay, great, thank you. All right, board members, any discussion on the stipulation?
Crystal Freitas, I don't have any questions. Dr. Gumina has taken ownership of his errors here, so I would move to approve the stipulation and order as presented for Antonio Gumina, MD.
I second. Sorry.
It's okay. Motion by Ms. Freitas, and I'll do second to Ms. Jacobo. All right, any further discussion?
Thanks, Adam.
Okay, hearing none, all those in favor? Aye. Any opposed? Okay, that motion passes. Thank you for your time today, Dr. Gumina.
Appreciate it. Thank you for your time and consideration.
All right, thanks. Okay, we'll go next to agenda item 5M for Tiana Hubbard. Tiana Hubbard, or representatives, if you could please come forward.
Greg, for the record, is she represented by attorney that you know
For the record, Greg Zanino, prosecuting this matter. Tiana Hubbard is the only respondent in this case that you just heard involving Respondent Escobedo as well that has not responded to the allegations. So I'm prepared to proceed with an application for a default.
Okay.
So I will do that, and I'll just walk you through this. The charging document begins at page 2518 as it pertains to respondent Tiana Hubbard. This is it's case number 24424 CSBS, and in this particular case, I sent to respondent Hubbard a notice of intent to take a default against her. And I would ask, I just ask Gisette Farrancode if she could testify and just authenticate this document for me.
Prepared to testify.
Yes.
Can you swear her in, please, ma'am?
All right, Gisette, if you could please state your full name for the record.
Gisette Narcon?
Ms. Panaricone, do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
So Gisette, you have a copy of the board book in front of you? Or maybe not.
You know, the attorneys are always tricky, just said, like that's, she does now.
Okay. So I ask you to scroll to page 2540.
Hold on, Greg.
Yes, I got it.
So you've reviewed that document, correct?
Yes.
You helped me assemble that document, right?
Correct.
Okay, now let me ask you to look at Exhibit 1, which is your declaration, correct?
Yes.
And that is your signature that appears on the declaration. And you affirm that everything in this declaration is true and correct to the best of your knowledge and belief?
Yes.
Okay, let me ask you then to look at and scroll down to the last page of that document. I'm still trying to get there. Well, so
Just when you get there, give us the page number.
I will.
Always get ready to put the page number.
So ask you to look at page 2576.
Okay.
And you recognize that that's a certificate of service that you completed, correct?
Yes.
And this indicates that you sent the notice of default with all of the exhibits 1 and 2, to Tiana Hubbard at her last known mailing address. And you also sent this via email, correct?
Yes.
And did you send this via email to Tiana Hubbard's last known email address? And to the best of your knowledge, did Tiana Hubbard ever respond to this?
No.
That's all I have for you. Just that. Thank you. So I'll say what I've done is I've prepared, at least in the notice, I prepared a proposed findings of fact, conclusions of law and order. That begins, it's Exhibit 2, the notice of intent to take default. It begins at page 2564 of your board book. However, I was initially expecting that none of the practitioners would respond, but 2 of the practitioners in the pharmacy tech did respond. They asked for continuances, so we continued those cases. And so what I've done is I've prepared a revised proposed findings of fact, conclusions of law and order, which basically takes the allegations that pertain to Tiana Hubbard specifically and incorporates them into a single document. And I believe that you have that. If you don't have it in front of you, I'll ask Darlene to distribute it, but I think you have it.
It looks like this.
This is a proposed findings of fact. I mean, if you adopt this, then ultimately I'll just ask President Park to strike the word proposed, and she can sign this as written. Essentially, the order at the end calls for a revocation of respondent Tiana Hubbard's certificate of registration number CS 25791. It further provides that she now shall not be eligible to petition for reinstatement for a period of 1 year It imposes a fine of $5,000 due and payable before July 31st, 2026. It orders Respondent Hubbard to pay costs and fees in the amount of July 31st, 2026, and this includes a finding that the costs were reasonable, necessary, and actually incurred. And I'll note that I've prepared to support the costs that I've suggested or recommended in this case, a memorandum of cost. Thank you, Laura. She'll distribute this to you. And so I will note that we're still very kind of early on in this case. I'm anticipating that we'll incur quite a few more costs and fees. There's as I said, there's like 14 or 15 more respondents in this case, but today I think we've incurred about $4,000 in costs, and I've allocated $1,000 of those costs to Respondent Hubbard, and I expect that at some point this case will go well over 10,000 in costs. So I think that's a fair allocation, and I think that we've incurred actual costs well in excess of that at this point. So that's my recommendation, and if you choose to adopt the proposed findings of fact, conclusions of law and order, you can just do so with a motion. I don't think you need to go through the facts of the law or the individual findings in that. Of course, you can make revisions or modifications to that too.
Greg, could you repeat which exhibit that's under?
You might not
I
remember.
think I have it. Is it page 2564?
Oh, you're looking for the page in the board book?
Yeah.
So there was an original proposal that included all of the practitioner respondents, and that begins at page 2564 of the board book. However, I prepared another one that pairs all of these allegations down so that they pertain specifically to Tiana Hubbard. And that is an exhibit that I think Darlene handed to the board members. So
And
that's
it's in your email, Jay. Just pull up your email.
Thank you. I think it's still pending on my end, but since I have access to the original and we're just pairing out that one respondent, I would move that we find, sorry. I make a motion that we find, make findings of fact and conclusions of law consistent with paragraphs 1 through, sorry, I don't have it in front of me. Can someone help?
Jade, maybe.
Jade, I think I would suggest you could just adopt, you could move that the board adopt the proposed findings of fact, conclusions of law and order that's been distributed to the board members.
Okay, perfect. So moved. Thank you.
We have a motion by Mr. Cobo, a second by Ms. Taylor. Any further discussion? Yeah, all those in favor?
Aye.
Any opposed? Okay, that motion passes. For the fees. Okay, this is Helen Park. I'll make a motion that the fee of $4,000 were necessary.
There's an allocation to Hubbard specifically on the second page.
Oh, is it, so just, yes.
Within the findings, fact, conclusions, law, or the it outlines on the last page that we believe that $1,000 was reasonable and so actually here.
It's $1,000.
I'm sure Todd's okay with it, because I know.
Todd is, yeah, Todd is.
I still want to, sorry, this is a senior dad, Todd Weiss. For the record, I still think we should do a separate vote on that because that part of the complaint is listed separately as an order. It's not in the paragraphs 1 through 58. So I think just to be safe, let's do a separate vote on that part of it.
Again, for another point of order, did that get admitted? I just want to make sure that that actually got admitted.
It was not admitted.
So if we can admit that first and then follow Todd's instruction, I think that would be best.
All right, so then for Tiana Hubbard's case, we will admit into the records Exhibit 1 and Exhibit 2. And then as far as the fees go, we'll do a
Senior Dad Todd Weiss, we could do a single vote on the proposed order for discipline, which does include the fees and costs and the finding that they were reasonable, necessary, and actually occurred. So we can do that in one vote. The order that starts on the second to last page.
All right, so this is Helen Park. I'll make a motion to approve the order that was presented to the board for Tiana Hubbard.
Second.
Okay, second by Ms. Taylor. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion passes. Thank you. Okay, and thank you, Mr. Weiss. We'll move on then to our next agenda item, and we'll go to agenda item 5R and 5S. That's for Walgreens Pharmacy number 03922 and for Mona Matar. So if you are present, please come forward. All right, hi, good morning.
Good morning.
If I could have you both state your full names for the record.
William Stilling, attorney representing Walgreens 03922 and Mona Matar.
My name is Mona Jordan Mutter. I'm the pharmacist.
Great. Ms. Matar, I'm going to swear you in. Do you swear that the testimony that you're about to provide will be both truthful and complete? Great, thank you. All right, Ms. Tucker.
Thank you, Madam President. This is Laura Tucker. For the record, this is items 5R, 5 and 5S. This is State B Walgreens number 03922. This is for case numbers 25-362-PH-S and 25-362-RPH-A-S. And these begin on page 2733 of the board book. I want to make a note that there was an additional respondent, Vera Diana Martinez. That's for case number 25-362-RPH-B-S. But that matter as to Ms. Martinez has been dismissed. By way of background, the allegation that the board made is that Ms. Matar, she filled a prescription for a minor patient for Focalin XR 10 milligrams. And in doing so, she inadvertently inputted the wrong medication for methylphenidate, also for 10 milligrams. The methylphenidate prescription was filled and the minor patient took the prescription and he complained that his brain was not working. And the patient's mother returned to the prescriber and the prescriber prescribed a higher dose of Focalin XR for 20 milligrams. When the patient's mother went to pick up the prescription, that's when she discovered the previous error that was made. We also have on here that Ms. Matar was previously disciplined In March 2023, she was disciplined for error in filling the prescription, resulting in no patient harm, and was fined $500. In October 23, she received a $1,000 fine for verifying the wrong dose of a hepatitis B vaccine. As a result of the allegations in the accusation, we charged Ms. Mosler with unprofessional conduct and for error in filling a prescription, and Walgreens number 03922 with pharmacy responsibility. And we also have for you today a stipulation and order for both Ms. Matar and for Walgreens number 03922. Those should have been placed in front of you at the beginning of the meeting. I'll make sure you've got some copies. So I will just briefly go through the proposed terms of the stipulation. For Ms. Matar, if you look on page 3 of the stipulation, she is agreeing that her certificate of registration shall be suspended. However, that suspension is stayed, and she shall be placed on probation for a period of 1 year from the effective date of this order. She will also pay an administrative fine of $2,000 due and payable within 30 days of the effective date of this stipulation. And to partially reimburse the board for recoverable attorney's fees and costs incurred, that amount shall be $1,000, also due and payable within 30 days of the effective date of the stipulation. And as a condition of probation, she shall not engage in any conduct for which disciplinary action may be imposed by this board. Turning now to the stipulation with Walgreens number 03922. I will briefly go over that. Starting on page 2 of the stipulation in front of you. Walgreens shall pay an administrative fine of $2,000 payable within 30 days of the effective date of this stipulation and order. And to partially reimburse the board for recoverable fees, attorney's fees and costs incurred, they shall pay the sum of $1,000 also due within 30 days of the effective date of this stipulation. And we'll go ahead and submit this to the board for discussion and approval. Thank you.
So before we do that, I'll turn it over to Mr. Stilling for any additional comments or remarks.
Thank you, Madam President, board members. This was a mistake, and I think we agree that the stipulation is appropriate. Appreciate the negotiations with Ms. Tucker, as always. And I just want to just let you all know that Ms. Matar proactively took CE about medication errors. She took it was a 2-credit course, I think it was University of Connecticut, for patient safety and med errors and their impact. And then another 2-credit hours on just medication errors. And I think I'll have her explain what she's done to improve. And I think some of this, I think she implemented that beforehand, but I think these CEs provided her with additional insight in her processes. I think the board members all know that Vocalin is methylphenidate, but it's dexmethylphenidate, so it's I think the right hand, dexterity, right hand. That's it's an isomer, so it's in case anybody didn't know, I wanted to make sure it wasn't just like, oh, these are 2 completely different drugs. And I think, anyway, I'll let Ms. Matar just, if you could explain what you've done to improve your processes.
So first, I acknowledge the mistake and I take full responsibility for that.
Can you walk here?
Oh,
yes, but if you could get closer, it would help. Yeah.
Hold this.
Thank you.
There we go.
So first, I admit that I made a mistake. I take the full responsibility for the mistake. What happened is I was typing the prescription and I was focused on the patient profile. He was on the methylphenidate, the CD form before. So for a second, I maybe I was confused, I would just focus with the profile. And for the methodology, because it has different forms, I usually prefer to scan the original file just to make sure that the patient is taking the correct one, the CD, not the LR or the XR or the spotted one. So actually, I was informed about the mistake like a month after it happened, so I tried to evaluate what happened. I didn't know at that time what exactly happened, but I was trying to evaluate what happened and how can I avoid that one in the future. I believe I scanned the model and then I feel comfortable to review it too fast. It's a mistake. It's a mistake. I admit that it's a mistake. Since I found with this mistake, I try to make sure not to have this mistake anymore and to improve my performance, my processing or verification process. So first, I start to deal with each step of the prescription processing differently and independently. It doesn't mean like I type the prescription, it should be correct. I have to recheck it as it's a new for me. So every step should be independently verified. Also, for any control medication, for any pediatric medication, for any higher risk medications, for all of these, I add an additional or do an additional verification. When I'm doing the product for the same category of these medications, I go again to the patient profile and I go again to the image of the prescription. It's usually when we review the product, it's not on the screen. So I go to the screen just to make sure that the patient is taking the correct one. This process or this step was really effective. I was able to catch and prevent some potential mistakes, including the doctor's mistakes. So this step actually helped me a lot to improve my performance. For the DUR and the PNP, I paid more attention for DUR. I kept look now for any if there is an interaction that we need to speak with the patient about. So either me or any other pharmacist that can help the patient with the consultation, they should be aware. With the PMP, I check if the patient was on a different medication before, or if the medication, the oral medication is new for him. So I put a note so the pharmacy should talk with the patient before getting this prescription and to be aware. Also for consultation, I'm doing when I do the consultation, I mention the name, the dose of the medications to the patient and confirm that the patient is aware what he's doing, what he's taking, and if there is any difference from the patient, what the doctor told me. This step also was really effective because sometimes the patient doesn't know if the doctor put if I can example, for example, he was on a water pills and the doctor put him in a combination with blood pressure and water pills. So I have to tell the patient, hey, did the doctor tell you that he's gonna increase or he's gonna add more to your prescription? So, and one of the things I also did Bill said, I completed some CDs because at that time, I wanted to know exactly how to avoid to make a mistake and how to improve my performance. I admit my mistake. I know I made a mistake. I'm so sorry for that. I just assure the board that I'm trying to do my best to help patients.
Great, thank you, Ms. Batar, for sharing that, and I'm glad that you take full ownership of what happened. I think some of the things you mentioned in terms of what you're doing now are very good practices. And I'm assuming you did not do those things during when this misfill happened, and that is why that occurred.
Misfilling the previous one?
Yes.
So for the previous one, it was actually different circumstances. I was just hired for Walgreens for almost 3 weeks. Everything was new for me at that time, and I was working in a very it was a high traffic pharmacy store, and during the flu season, again, I had made a mistake, like, it's my responsibility, it's my responsibility. But I can say that at that time, I wasn't really like feeling confident. But after having this mistake, like the previous one, it was my goal is how to improve my confidence and how to work in a high traffic pharmacy. I was able to succeed to that because for almost 4 years now, I didn't do any mistake because it was the stress around me or because I was rushed by the patients or anything. Like I was always taking my time. I always to take the time that I should take. So I didn't do any mistake regarding to the previous one.
Okay, great. I'm glad to hear that. Thank you. And then, Mr. Stilling, you had mentioned some CE classes. Are those ones that have already recently been taken, or how they tie in? Could you?
They were taken in August before this case was filed, and she did it because she felt like it was good to take, some additional classes in error prevention and the effects of errors and those sorts of things. So it wasn't because this was filed and then she took them. It was actually, she took them. Am I correct? It's in August last year? Okay. So, she mentioned a couple of things. I just want to make sure it was clear that, about cap lock, and I think I can quickly explain that. It means that if there's a DUR, she puts a comment in there, it actually, the prescription cannot be filled until another pharmacist or she releases it after looking at that comment. So that's what that meant. And I think, and I hope it was clear that in this case, she filled in the data, she entered the data and then checked it. And I think she realized that was it's kind of like a cognitive bias, checking your own thing. And some of the comments she said were really meant to alleviate that problem and be cognizant of the fact that if you do that, you really need to be more careful checking. So I think, anyway, I just wanted to make sure those were clear. Well, one step she mentioned was just again to be clear about the process when during the product review, when the screen comes up with the medication, if it's in a certain class of drugs, I think, correct me if I'm wrong, pediatrics or controlled substances,
medications.
Thyroid, thyroid, things like that, that she will then, it's just hitting a button for the original prescription. So.
Okay, great. Thank you. Board members, any questions?
Adam, for the record, the term high traffic, this is a high traffic store that's been said a few times here. Could you, one of you tell me what the average daily prescription numbers are at the store?
Is that for this mistake for the new one? Or
Walgreens 3922. How many prescriptions do they fill on average a day?
we are tier 5, but still because I cannot see exactly how many prescriptions we are doing.
What is tier 5?
Tier 5, it means like this is a higher tier of pharmacy, like we are filling the higher volume of the prescriptions or higher number of the prescriptions.
Yeah, I guess I think Ms. Vatar said that she was that this mistake was not caused by being rushed or anything like that. So I just want to make sure the record's clear on that.
If I can, maybe I wasn't clear. So this mistake again, it wasn't because I was rushed about anything around me. So this mistake, it was because I was confused by the patient profile, and I was trying to be accurate. And this is why I scanned. I went to the safe. This is what I can. I believe I did because this is how I'm working with methylphenidate exactly because of the different forms. So I believe I went to the safe, I grabbed the bottle, I scanned it. So it wasn't because I was rushed for this mistake. It wasn't because I was rushed. It's totally my mistake. I admit it. I just try to be honest. So.
Are you the managing pharmacist at this store?
No.
Ms. Taylor, Ms. Matar, can you clarify for me when you say you were confused by the patient's profile? Was that during data entry or where was the confusion?
Yes, it was during the data entry, so, for the methylphenidate, when I type for any control medication, I usually go through the patient profile to check what medication he was taken before. This medication was on the methylphenidate CT before, and this is why I felt I was confused because of that. So I confused that the patient is still on the methylphenidate. So it was during the data entry.
And currently, is there a process in place if you're the one inputting the data that the pharmacy manager or another pharmacist can verify that? So you're not checking your own work?
I'm trying to do that actually. When I type the prescription, I just leave it for a different pharmacy to review it because we usually have an overlap. And in case like I'm the only pharmacist in the pharmacy, I don't actually type. Usually I just leave it for the technicians to type, then I can review just to avoid having the same mistake.
And one more question. I know you were stating the steps that you've taken afterwards. And you mentioned reviewing the screen and the image of the product. Do you also do a final product check visually yourself, or is it just via the screen?
No, actually, I don't understand.
You visually inspect the product yourself?
Yeah, of course. Like when we have the product on the screen, we see the description of the medication, we open the vial and we check that this is the correct medication. But for these categories of the medication, I go again to view the screen just to make sure that, or view the original prescription, just to make sure this is the correct one, this is the correct medication, this is the correct I'm sorry, this is the correct direction, this is the correct day supply, and like this is the correct patient, like everything about these prescription, these categories of the prescription. I started from what I heard about this incident, I just go into to view the image for each one.
Any other questions, board members, concerns?
Adam Ports for the record, I guess the thing that's bothering me is that there's a list of prior discipline, both from the store and from Ms. Matar specifically. This is your third time that you've had discipline from the board related to fixed bills. So I really don't want there to be a form.
And last one, the previous one actually was almost like more than 2.5 years. During this break, I worked on myself to improve my performance and to avoid this mistake. It's a different mistake. I don't justify the mistakes. I know mistakes are not acceptable. But I'm doing my best to improve my performance, and I'm trying to take plans, and I already have taken steps to improve my performance. And consistency, I'm consistent with each step. I've already taken. I'm doing with each one. I have no issue for a year now. I didn't do any issue. I'm very confident to follow prescription, to review the prescription, to help the patient and to consult the patient.
And I appreciate your efforts in the process.
So, Mr. Porath, I mean, something the board can consider is extending the period of probation in this case, if you are concerned about the repeated errors within the time frames.
Yeah, I just think that, when pharmacists come before this board and there's a couple of mistakes in the background, I think it's important to remember that, pharmacists make mistakes. Some of them come before this board, probably a smart problem. I don't have the data. And it's almost, it's unfortunate that it's what gets reported. And so in this case, and the mistakes that were made, this one was a pediatric patient. Those are the type that get reported. I think the prior one, there was misfill of the hepatitis. And before that, it had to do with listening to a phone call on doctor. It's kind of, she said kind of thing, where the doctor said, I ordered one thing and Ms. Maytar said, no, I heard something else. So I don't think she has a history of a lot of mistakes. What happens is through just bad fortune, these are mistakes that get reported. There might be other pharmacists out there that make a lot more mistakes and you just never see them because they don't get reported. So I think that the term of this, we negotiated this for 1 year. She's already had 1 year since the incident. And so I think this is a fair settlement.
So and you make some points, but we're dealing with what we have in front of us, right? And so we're here and we're trying to do what's safe for the public. So I appreciate your comments, but we're dealing with the matter, right? So board members, just for our discussion, any other thoughts or comments?
Crystal Reyes, I think with the history of errors, I wouldn't be opposed to extending the probation period if others agreed.
And of course, for the record, I would agree with the extension to 2 years probation.
And Mr. Tilly, we'll give you a moment to discuss it with your client. Just
Yeah, and maybe Ms. Tucker.
yeah, when the time comes, there's no issue with that.
Yeah.
Okay, board members, any other comments? Sounds like there's some consensus to increase the probationary period to a period of 2 years.
So I think the board staff has that and we can go. Adam, did you want to say something? I'm sorry, I didn't.
Sorry, I haven't worked for the record. I was just gonna say, otherwise, I'm fine with the stipulation.
So if you just take a break, it's about time anyway, and then Laura and Bill can talk and then we'll see if we can come to an agreement. And if not, then you'll vote on the stipulation that's in front of you.
All right, we'll go ahead and take a quick break. All right, we're back with Walgreens Pharmacy 03922 and for Laura Matar. So I'll turn it to the attorneys.
We discussed it. I think, we recognize there's consensus for 2 years. If we took a vote, my sense is that the stipulation will get rejected at 1 year, so we'll go to modify it for 2 years.
Great, thank you. All right, board members, do we have a motion?
Shanice Taylor, I do move that we approve the stipulation with the amendment of the suspension of the probation for a period of 2 years, effective of the date of this order.
Anna Carr, second.
Okay, we have a motion by Ms. Taylor, a second by Ms. Carr. Any further discussion? Okay, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. All right, thank you. Thank you for your time.
Madam President,
Yes.
we need to separately approve the stipulation for Walgreens.
Oh, that's correct.
That is correct, yes.
Thank you.
Please return.
There is I don't know that Ms. Maytar has returned.
Ms. Maytar does not need to return.
Before you do that, just for the record, board member Jade Jacobo has left, so she did not vote on this.
Okay. Thank you, Mr. Porath. And now for the matter
I'm
of
used to having
stipulation.
stipulations combined.
It's okay. All right, so for the stipulation for Walgreens Pharmacy, I'm okay with the stipulation as presented.
Agreed, Madam President. Shanice Taylor, for the record, I do move to approve the stipulation as presented for Walgreens.
Okay, we have a motion by Ms. Taylor, a second by Mr. Porath. Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, that motion passes. Thank
Thank
you.
you so much.
Thanks again, Ms. Porath. All right, so we'll move to our next agenda item, and that is agenda item 5B for Joseph Steidel. So if we have Joseph Steidel, if you could please come forward.
But did you have communication with Mr. Steidl? Did you?
None, I have prepared to.
Thank you. Madam President, nobody on Zoom identifying himself as Mr. Steidl.
All right, I'll turn it over to you, Mr. Cant.
Greg Camp for the record, prosecuting this matter on behalf of the state, case number 20019 RPHS. The respondent, so named is Joseph Eric Steidl. RPH certificate registration number 18852, charging document against Mr. Steidl begins on page 2235 board book. The other respondent, Modern Pharmacy license number PH 04065, on the related case, contacted the board late. So by way of brief background, board staff had some difficulty locating both respondents. Eventually, counsel for Modern RX contacted the board and indicated their intent to appear and defend the proceedings, so that will be noticed for a later date. I am prepared to proceed with the default today against Mr. Steidl if the board is so inclined. If you want to wait on a default against Mr. Steidl for a future hearing for Modern RX, I'm prepared to go either way, whatever your preference is.
We can get it done. What? We're ready.
This is Senior DAG Todd Weiss. Counsel, is there any reason to believe Mr. Steidl is planning on opposing?
I'm sorry?
Is there any reason to believe Mr. Steidl is going to oppose the discipline against him?
No, there's no reason to believe that.
So we can bifurcate it.
Okay, all right, we'll go ahead and proceed.
I'll proceed. So once again, the charges set forth in the accusation, the board book, are that Mr. Steidl was employed as managing pharmacist by Modern RX, and that during an inspection, Mr. Steidl made false representations to Board Inspector Joe Dodge relative to the activities of the pharmacy. Those false statements are set forth in charges, and of course, willfully making a material false statement in the court of a board investigation is a criminal offense. That's ground for discipline. And the managing pharmacist, Mr. Steidl was the managing pharmacist as well, and responsible for the operations of the pharmacy, in addition to responsible for his statements. And so with that, I am first prepared to provide a declaration from board staff as to attempted service of the accusation and the notice of the hearing today upon Mr. Steidl in conformance with Nevada law. I would ask that that be entered in the record as Exhibit 1.
Right, so admitted as Exhibit 1.
With that, I'm prepared to ask the board to make findings of the applications of law. Take disciplinary action against Mr. Steidl. If I may, Madam President, I'll make those recommendations. Okay.
Only, but Mr. Cant, did you want to also admit there looks like there's an Exhibit 2? Or are we combining?
It's a little bit. Correct, but I'm sorry. I know that the documents appended to the declaration are marked as exhibits. But I just want a whole package, the declaration with the supporting documentation.
Okay, great. All right, thank you.
So first, I would ask the board to find that it has jurisdiction and make findings of fact consistent with paragraphs 1 through 3 of the accusation.
Crystal Freitas, so moved.
Second.
Motion by Ms. Freitas, second by Ms. Taylor. Any further discussion? Okay, all those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes.
Next, I would ask the board to make conclusions of law consistent with paragraphs 4 through 8 of the accusation and find the respondent, Mr. Steidel, guilty on count one. Please disregard count two because that's against the policy. You find Mr. Steidel guilty on count one. And also find, in addition, that Mr. Steidel was properly noticed of the charges and this hearing compliance with that law.
So move. Second.
Okay, motion by Ms. Freitas, second by Ms. Taylor. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion carries.
Next, I would note that Mr. Steidel's registration number 18852 is expired. But you may revoke an expired registration, so I would request that you revoke the registration, provide for the minimum statutory period of 1 year to petition for reinstatement. And I also will be asking for recovery of attorney's fees and costs, but I need to pass that out to you. So initially, let's just go with the revocation.
Crystal Freitas, so moved.
Second.
Motion by Ms. Freitas, second by Mr. Porath. Any further discussion? Okay, all those in favor, aye.
Aye.
Any opposed? Okay, that motion passes.
And then next, I'm passing out a memorandum of attorney's fees and costs that are recoverable pursuant to NRS 22-400 in this case, totaling $190.95. I would ask it into the record and ask that you award recovery of $190.95 on the basis that it was reasonable, necessary, and actually incurred in this action. I would also ask that you were to be effective immediately.
I'll start with admitting it as Exhibit 2. Yeah, I'll make a motion. This is Helen Park, that the fees were necessary and actually incurred. Of a total of $190.95.
Second.
Okay, second by Ms. Taylor. Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, that motion passes.
And if the board has no other discipline it wants to impose, I would just ask that that order be effective immediately.
Just to clarify, Madam President, on your motion, and we are charging those fees to the.
Yes. Yeah, so I could amend it so that the fees are necessary, reasonable, and actually incurred, and that the total amount of $190.95 will be charged to the respondent due in 30 days. And that is, okay. I think I got everything. That's a revised motion. Is there a revised second?
Second.
Okay. Any other discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion passes. Did we cover everything, Mr. Cant?
Thank you.
All right, thank you. All right, so we will continue on. Next on our agenda, we have Darlene Hess for 5D. 5D, Darlene Hess, if you could please come forward.
Raise your hand on Zoom. Dave, we for record not seen anybody, Madam President. That may be expected. Mr. Cant.
Yeah, I'll turn it over to you, Mr. Cant.
Give me one moment to get to the right page of the question. For the record, prosecuting this matter on behalf of the state, this is case number 24460 PTTS named respondent Darlene. Not quite sure how to pronounce her middle name, Hess, PTT, certificate of registration number PT 227744. Charges begin on page 2263 of the board book. There's some additional documentation in there in the form of her original application for registration as a pharmaceutical technician training, which begins on page 2272, and her application for registration as a pharmaceutical technician, beginning on page 2284, and finally a criminal history from Las Vegas Metro Police Department that the respondent provided began at page 2289 of the board book. Just want to note that this matter was noticed for a hearing at the March Las Vegas board meeting. I was prepared for a default with the respondent, although having not previously responded to the charges, appeared that day and requested a hearing. So that's why we are here today, but it doesn't appear the respondent's here today. So I'm prepared to proceed with the default, but by way of brief background, the respondent has a fairly extensive criminal history as detailed in the accusation and in the actual criminal history that she provided to the board upon further investigation. She failed to disclose that criminal history on our 2014 application for registration as a pharmaceutical technician in training. She was issued her certificate of registration, and then she subsequently failed to disclose that criminal history on all subsequent biennial renewal applications through 2022. And so once again, she furnished false material information to the board and obtained registration by fraudulent application. So I am prepared, since it appears that the respondent has failed to show to proceed with a default hearing today.
Okay.
So first, I have a declaration from board staff as to service of the accusation upon the respondent in conformance with Nevada law. And I would ask that that be admitted into the record as Exhibit 1.
Okay, so admitted as Exhibit 1.
Next, I have a declaration from board staff documenting that the respondent was properly noticed of this hearing today in compliance with Nevada law, and I would ask that be admitted into the record as Exhibit 2.
So admitted as Exhibit 2.
And with that, I'm prepared to request that the board make findings of fact to the law. So if I may, Madam President, first, I would ask that the board make findings of fact, findings as to jurisdiction and consistent with the allegations in the accusation, make findings of fact in accordance with paragraphs 1 through 4 of the accusation.
So moved. Crystal Freitas, a second.
Okay, we have a motion by Ms. Taylor, a second by Ms. Freitas. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion passes.
Next, I would ask that the board make conclusions of law consistent with paragraphs 5 through 10 of the accusation and find the respondent guilty on counts 1 and 2. In addition, make a finding that the board, the respondent was notified of the charges in this hearing in conformance with Nevada law.
So moved. Second.
Okay, we have a motion by Ms. Taylor, second by Ms. Freitas. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion carries.
Next, since it looks like the board will be entering some discipline, I'm going to, consistent with that 622-400, provide a memorandum of attorney's fees and costs that are recoverable. Those total $1,268.54. And I would ask this be entered into Exhibit 3.
Okay, so admitted as Exhibit 3.
And then I would ask, by way of discipline, that the board revoke respondents' certificate of registration number PT 27744, that the respondent have to wait the minimum statutory period of 1 year, which you can petition for reinstatement, that the board award recovery of the $1,268.54 in recoverable attorney's fees and costs as reasonable, necessary, actually incurred, payable within 30 days, and the order be effective immediately.
President Brady, so moved.
We have a motion by Ms. Freitas, a second by Ms. Taylor. Any further discussion?
Adam, for the record, I think this is another case where, it's just interesting to me that, with the newest, and renewal that has the big warning, that all of a sudden it was then disclosed that, the criminal history is there. And again, it's unfortunate that we don't have, her here to maybe give her side of the story of why that occurred.
Rep Camp, I could just point out, Nevada law was changed with regard to conducting background checks. And now, prior, there were not background checks conducted, criminal background checks conducted for this class of licenses. But now they are. And so I think you're going to see a few instances where there were individuals that were licensed, did not disclose the background, and then it comes up later. And then they'll be called before you to account for that, their failure to disclose.
All right, so we have a motion and a second. Any further discussion? Okay, hearing none. All those in favor? Aye. Any opposed? That motion passes.
Thank you.
Thank you, Mr. Pant.
All right, Madam President, I'm going to ask you to take a really quick recess. Staff has to do a couple things. I will put on the record because I've been asked, and it just was the timing of it. Item number 15A, which is public hearing for LCD file R038-26, which is called, oh, no, sorry, wrong number. LCB file R072-15, staffing regulations. That'll be tabled, so we won't be hearing, we won't be calling that. There won't be public comment on it. That we still may receive public comment at the other times that you take public comment, but that will not be an agenda item for this meeting. I asked for a quick recess for staff to do a couple items.
Okay, we'll take a quick recess. Thank you. Okay, we'll continue with our Board of Pharmacy agenda. We're going to hear agenda item 5G, Raley's Pharmacy, number 123. We have representatives. Please come forward. Hi, good morning.
Hi, good morning. Can you hear me?
Yes, we could hear you.
Yes, it's Tim Cools, KUHLS, on behalf of Ravens.
Great, thank you.
And you're an attorney barred in Nevada?
I am correct.
You're supposed to give your bar number.
Give me 6'2", there should be a formal appearance, right?
Thank you. All right, I'll turn it over to Mr. Zanino.
Thank you, President Park. For the record, this is Nevada State Board of Pharmacy versus Raley's Pharmacy, number 123. Pharmacy license number PH 00999. This is case number 24366 PHN. There was a related case that you heard last meeting. That was case number 24366 RPHN. That case was resolved by stipulation. It involved Patrick Awa, a pharmacist, and he appeared. This is the follow-up case to that. The parties have reached a stipulation and proposed order for your consideration and possible approval. I'm sorry for kind of the lateness of this. Mr. Coles and I had some kind of miscommunications and we didn't kind of get this nailed down until today, but I believe that Laura distributed paper copies of the proposed stipulation and order, and I think Darlene was going to send email copies to the board members that are appearing via Zoom. I will cover or summarize for you the key provisions of this, and I'll note that first that the count one of the accusation alleges that Raley's had a system that wasn't kind of properly documenting counseling. They had a computer system that wasn't properly documenting the counseling. We've actually gone out and we've inspected the system. I had Mui Lee go out and look at it, and I think we still have some concerns, but we're willing to kind of move forward with this. So they deny that the system is deficient. However, they don't contest the allegations as stated in count two, and they admit that they are vicariously liable or that they're liable by virtue of statute for the conduct of Patrick Awa. Those allegations are outlined in paragraphs 7A through 7F of the proposed stipulation. To resolve the case, respondent has agreed to pay a fine of $750,000, not $750,000, $750. And that by the
We have to have a printed copy of the stipulation.
That, by the way, is the exact same punishment that was imposed upon a pharmacist, Patrick Awa. That would be due and payable on or before July 31st, 2026. Respondent agrees to pay the sum of $500 to reimburse the board for removal costs and attorney's fees payable on or before July 31st, 2026. And again, that is identical to the costs and fees that were imposed upon respondent Awa. Additionally, respondent, we note that respondent has cooperated and agrees that it will continue to cooperate with the board's inspectors in terms of explaining or demonstrating how a system for documenting patient counseling operates, and agrees to make reasonable changes or modifications to that system as appropriate to address any compliance concerns that the board may have. The stipulation constitutes a full and final resolution of the accusation in this case, and it will, of course, be reported to the National Practitioner Data Bank in accordance with federal law.
Thank you, Mr. Zunino. I'll turn it over to you, Mr. Coles, for any additional remarks or comments.
Thank you. Yeah, just a few additional remarks. Just to kind of second what Mr. Zunino said, we've been in contact since February as to timing being here today. We've been going back and forth. I think one of the reasons that we're here today, and things are coming kind of, I don't want to say together at the last minutes, but the reason why we come to this agreement now is because we actually did end up having investigators when we ended up going back out to Raley's in Reno to show that, for my client, for them to show how this computer system, how this database worked in conjunction with some of the allegations that are contained herein. My client's understanding was that that took place. There was no issues with that. I believe that was on May 11th. I don't think council has presented us with a second investigative report. The only one that was kind of submitted back in 2024. That's essentially why we're here today. So my understanding is that for my clients, some of the concerns I think that the board had, certainly that the investigator had, are all taken care of, and that we're all now on the same page there. With respect to Mr. Zunino's comments on the allegations, Anytime I hear the word liability, my red flags go up. Just to be very, very clear, my client does not believe he's liable when we enter into this settlement agreement or settlement terms that we're going to regards to resolution. We acknowledge all of the accusations that are in front of us. Certainly, my client has no interest in offending the board, offending the public. These are our customers, right? Certainly to the point that we want to forward everybody being on the same page, ensuring that certain consults are occurring. We want to do that. We've now taken measures to actually change our consulting computerized software. My client is in the process of that.
Can you tell me a little bit more about that? Because that's the part that concerned me the most, where it says the default is always yes. And so if you can comment, that would
Yes,
help.
clarify that. So my client says that basically when you go there, this has to do with a customer who was presented with new medication, I believe, for her husband. Okay, these were antibiotic ear drops. When she goes to pick those up, my client has a computerized system where automatically when it is a new prescription, you have to authorize that this is a new prescription, and essentially flags the fact that you are going to get a consult. Okay. They then take you from the point where you pick up those medications, they put you in a different part of their pharmacy, you go to a different window. My client, I think one of the issues that we have here is that with post-investigation reports, the fact that this was kind of complained about so much later after July 2024, I believe the investigative report didn't occur until September. There was nothing to look back on. It was really just computerized records. There was a call, I believe, to Mr. Awa. And then at the same time, there was a request for video, right? My client has surveillance video of the pharmacy that tapes over itself after every 30 days. That was unavailable. We were just not able to go back and verify, have anybody with personal firsthand knowledge of that interaction. Nobody interviewed my client. That said, we go back to our computerized system to go what had allegedly occurred. Claiming to say that there was no consult that took place. My client says obviously that there was, and apparently Mr. Awa, not my client even knowing that he had actually spoke to the board, said he couldn't remember. So it's kind of a, I don't want to say he said, she said, but we always default back to our computerized system. We don't think it was deficient anyway. To the fact that it was defaulted, you're right. It wasn't that there was any specific information to go back to that to show that that actual specific consult occurred. My client is saying that absolutely would have occurred.
And you mentioned that some changes are being made. Is that correct? Can you tell me about the changes?
They're going to end up having a new computerized software with new, it's not going to end up being the same consult service. There's also discussion, and I can say this with confidence that from the Rayleigh's pharmacy director, they're out of Sacramento, but they couldn't be here personally today. But they are taking measures to kind of have new prompts and new ways of documenting certain cases where they can go back and actually look at what actually happened versus what was done.
So that I'm glad to hear that, because that was the concerning part of here, is that if it defaults to, then you never know, because it just marks it that way. And so I think from that perspective, from a like patient counseling, we need to know that it happened, or if it didn't happen, or if they declined it, and that system that your client has doesn't seem like it meets that. All right, board members, any additional questions, comments?
Yeah, Adam, for the record, I do just want to clarify in the meeting minutes, the April meeting, it indicates that Patrick Awa paid a fine of $1,000. So it would be an odd situation that we would have a reciprocal fine for the store of less than what was the pharmacist's fine.
Is that in the minutes?
It's on page 21 of the board book.
This board, today's board book, 21. I think.
The reason we agreed to this was it was represented to me that the $750 plus the $500 was what Mr. Awa had paid. So that was my understanding of the agreement as well.
So the minutes say it's 1,000. If we go back to this actual stipulation, it was 750 because that came right out of the schedule of fines that exist in the NAC. So that's inaccurate, and I should have caught that when I reviewed the minutes.
Okay, so Adam Porthy, for the record, as long as it's consistent with what the pharmacist was fine, I'm okay with it.
I think for board staff or Greg, do we have the actual order from the other one? We'll just go to the order and make sure.
I would feel better with that.
Catch Adam, so we'll just go to the order. You have the order? Okay. Can you state your name for the record?
Sorry.
And your position with the board?
Board coordinator. Sorry, Jenny Nossis, board coordinator, and all the respondent paid $750 as fine and $500 mentioned fees and costs.
So Adam, apologize for that. We'll fix the minutes, so we'll have that. Good catch. Thanks.
All right, with that, ready to make a motion?
Yeah, again, Adam Porthy, for the record, I had the same concern that you did, President, just with the conversation we had around the last board meeting, so feel a little bit better about that now. So go ahead and move that we approve the stipulation order as presented by Mr. Zanino for Rayleigh's Pharmacy 123.
Crystal Branson, second.
Okay, we have a motion by Mr. Porath, second by Ms. Freitas. Any further discussion? All right, hearing none. All those in favor? Aye. Any opposed? Okay, that motion passes. All right, thank you for your time.
With Amazon, make sure we get it done.
All right, we're gonna move to agenda item 10A, Amazon Pharmacy number 051. And just to note that this is not a disciplinary matter. Hi, good afternoon, or good morning still.
Good morning. My name is Luis Lance. I'm outside counsel for Amazon Pharmacy.
Okay, great.
Good morning. My name is Jovis Quadros. I'm managing pharmacist for Amazon Pharmacy.
Mr. Quadros, I'm going to swear you in. If you join me in raising your right hand, do you swear that the testimony that you're about to provide will be both truthful and complete?
Great.
Thank you. Okay, and I will turn it over to Dr. Long.
Thank you, Madam President. Yan Long for the record. This is item 10A located on page 3190 of the board book. PillPack LLC, doing business as Amazon Pharmacy number 051, is applying for a pharmacy license to operate a retail pharmacy in Las Vegas, specifically offering 30-day home delivery with patient-specific multi-dose packaging. As introduced, Dr. Quadros is the PIC as well as the designated representative. He graduated from pharmacy school in 2019. And he has worked for Amazon as a pharmacist in Miami from 2019 to 2026, based on his designated representative application. So I do have some questions for the pharmacist in charge, the PIC, Dr. Quadros. It's stated in your designated representative application that you are currently working for the Florida Amazon Pharmacy. Are you still working for that location currently?
Yes, I am.
Okay. And it looks like based on your application, you still reside in Florida. Is your intent to move to Las Vegas once this application is approved?
Not necessarily. I am acting as the managing pharmacist while we facilitate the licensure procedure. The pharmacy is actively seeking a local candidate in which we will promptly notify the board to transfer to reflect the new managing pharmacist.
Okay, so do you understand that in Nevada pharmacies must be managed by a pharmacist located in Nevada? So if you guys do get licensed, you would need to have a managing pharmacist in place in Nevada immediately. You can't go without a managing pharmacist, and you can't manage the Nevada location pharmacy from Florida. Do you understand that?
Yes, that is understood and is in the plan.
Okay.
And just to jump in here, so the pharmacy is currently being constructed. And so it's set to open, we're thinking in October, or Q4 of this year. So Amazon is trying to be proactive in trying to get its license prior to the opening and actual operation of the pharmacy. So Joe was listed as a pharmacist manager with that in mind, that they're looking to hire a permanent local pharmacist who will be the pharmacist manager while the facility is being constructed.
Okay, great.
Dave Weeks for the record. I think Yen, I mean, what you're doing is within law. We allow this all the time. And Yen knows it too. She's just making sure he understands what he's signing on for potentially.
Okay.
Yeah, thank you very much, Mr. Weist. All right. Can you explain, this is for the PIC as well, the services that will be provided by this Amazon pharmacy location in Las Vegas in a little bit more detail? Yeah, you mentioned that there's a 30-day home delivery with patient-specific multi-dose packaging. Can you explain that to me?
I'm sorry, the site won't be dispensing multi-dose packaging. We'll be providing regular interviews and pharmacy valve dispensing.
Okay, so it'll be just regular dispensing. Are you guys doing like bubble packaging? It just is a little confusing what it means by multi-dose packaging. I wasn't quite sure what that meant.
Yeah, there's no intention to dispense customized patient packaging.
I think it's probably on the application, which I can bring you. If do you have a copy of it, Louise, or I can bring you in? I think Yen's probably, Yen, can you just reference where that is on? I'm sure
Yeah, that is page 3190 of the board book on the very first page of the application. You checked other and it said 30-day home delivery with patient-specific multi-dose packaging. And I just wanted some clarity on what that means.
So,
you're allowed to revise it now, so if it's not gonna be that, just tell the board what you think it's
Sure.
gonna be. And then in the future, things change and you can change it then. It just, Yen's just going off of what you said.
right, and I think the intention here was for the pill packs. But I have to go back to the client to make sure that they actually intend to dispense those, or Joe, I'm not sure if they.
Maybe for the record, today could be either one. I think the board may still grant it. I mean, both are legal, so I think the board just wants to know what you're up to.
Yeah, I just confirmed, we do not intend to dispense pill packs out of this facility.
Okay, but in the future, if you choose to, you could, so.
It'll just be conventional pharmacy valves and unit of use dispensing.
Okay. And so it'll be just a traditional retail pharmacy is open to the public to come in and drop off prescriptions, or how do you guys receive prescriptions?
Yes, thank you. Providers can send prescriptions via e-prescription, or patients can also transfer in the prescription by providing their pharmacy that they currently get dispensed from, and their medication list. And then we'll do all in-house processing, fill and dispensing to the patient.
Okay, and it will be home delivery only? Sorry.
Sorry, it is a closed door pharmacy that will provide home delivery.
Okay, so did you say it was closed door? Sorry, I missed that.
Yes.
Yes.
Oh, okay, closed door. Okay, good to know. And can you explain why a patient would choose your pharmacy over another?
Yeah, good question. Our focus is delivering same-day delivery medication. This move will expand our network and bring us closer to our mission in making medication accessible to patients nationwide. And we're customer-centric, where patient safety is at the core of what we do. And we really stand true to that core.
Okay, thank you. And so, since I'm kind of unfamiliar with like the Amazon model, will a patient be able to just go online and order medications as they need, or is there a prescription that you will need in order to process a prescription? Just wanted to know how that works.
Yes, good question. So the Amazon pharmacy is within the Amazon.com platform. Patients will do all the in-house processing of the prescription. It'll be on file. And whenever the patient is ready, they can order their medication directly through Amazon.com.
Okay, but they would.
The dispensing is pursuant to a valid prescription issued by a prescriber.
Okay, perfect. Thank you. And then you listed some disciplinary actions in the application, and I just want to bring up three of the number of disclosures here. You mentioned that you guys in, I think it was 2022, the United States District Court, Southern District of New York, and PillPack ended up in a settlement where PillPack was alleged to have violated the False Claims Act for fraudulent over dispensing of insulin pens to Medicare and Medicaid beneficiaries. And then in the settlement, it looks like PillPack paid $5,600,000 approximately to the U.S. government. Can you explain what happened there and how PillPack will in the future and now how you guys are preventing that from occurring?
Sure. So at the time of the content that was at issue here, insulin pens were only provided in a box that contained essentially 5 insulin pens. And FDA guidance at the time didn't allow the pharmacy to break down that box and dispense individual insulin pens. So what they were doing was dispensing the full box. And in some instances, it was more than what was prescribed for. And so this was an issue and they've corrected it. And essentially now you are able to dispense individual insulin pens per FDA. So they've implemented systematic changes to make sure that they are not over dispensing the insulin pens and that they're dispensing the quantity that was prescribed by the prescriber.
Perfect, thank you. And then in June of 2023, PillPack entered into a settlement agreement with the DOJ for violations of controlled substance record keeping, in which PillPack stored inventories and records of Schedule 3 through 5 controlled substances with other non-controlled substance records. Additionally, PillPack records did not accurately reflect PillPack's inventory of Schedule 3s through 5 controlled substances. And in that settlement, it looks like PillPack paid $300,000 to the DOJ. Can you explain what happened there and how PillPack has prevented or implemented procedures to prevent that from occurring in the future?
Yeah, so the main issue here was related to record keeping. And essentially what was identified as the issue was that PillPack maintained records for Schedule 3 through 5 together with records for non-controlled substances. And so that was the main issue. And then there was issues with the inventory, but there was no losses that were associated with the inventory discrepancy. And PillPack has changed their record keeping practices and modified the policies and procedures related to record keeping of controlled substances.
Great, thank you. And then in February 2024, PillPack entered into a settlement agreement with the OIG as a result of self-disclosures to the OIG that PillPack accepted pharmaceutical manufacturer co-payment coupons and other co-payment assistance programs for federal healthcare payers and provide prescription drugs exceeding the prescribed amount on billed Medicare, Medicaid, and TRICARE. And then it looks like PillPack paid a settlement of $646,000. Can you explain what happened there and what procedures PillPack has implemented to ensure that does not occur in the future?
Yes, of course. So the main issue was the provision of copay cards to government beneficiaries. And the reason why it happened is essentially PillPack was working with third parties who were not properly screening these government beneficiaries and excluding them from the copay coupon program. And so since then, they have increased the checks to ensure that no government beneficiaries are being included in the coupon program. So that was one issue. And then the other one related to what was it? It was the over dispensing. And what had happened there, it really related to record keeping of partial fills. And essentially what was happening in order to do med synchronization, if, for example, you were going to get a 30-day supply on July 1st, what they would do is, in order to get you to July 1st, they would do a partial fill. And unfortunately, the system wasn't keeping track of the partial fill. So they were over dispensing more than what the quantity that was prescribed because of the partial fill, and they were billing the federal government for that.
Great. And you guys have a system now that does record partial fill, so that won't be an
Yes.
issue in the future. Okay, very good. I think that is all the questions I have. I'll turn it over to the board for any additional questions.
Yeah, Dave Weiss for the record, just one other point. There was some disclosures that came in just in the last week. So Jens reviewed those, the board has that. So I just put it on the record that all your disclosures are in front of the board.
Thank you. And one other point, this discipline and settlements that we've been discussing related to other PillPack pharmacies that are licensed in Nevada, and the discipline has been reported previously to this board for those non-resident licenses.
All right, very good. I was just curious about what your pharmacy software, what software are you using?
We use a software called Pharmacy Lite. It's an advanced processing system that's proprietary to Amazon. We also use a ticketing system known as Tachyon anytime we need to follow a escalation matrix.
Okay, all right, very good. I don't know if my mic has gone as well. All right, any other questions for Amazon? If not, I'd feel comfortable based on the testimony today and talking through the disclosures to move forward with their application.
Crystal Freitas, I'd move to approve new pharmacy application for PillPack Pharmacy.
Second.
Okay, motion by Ms. Freitas, second by Mr. Porath. Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, that motion passes. We wish you all the best.
Thank you so much.
Thanks. All right, next we will go to agenda item 6B for Oxis America. So if we have representatives for Oxis America, you could please come forward.
Madam President, that's one that that we had agreed to with Oxis some time ago to continue, and I don't know.
That's on me.
Oh, okay. All right, so agenda item 6B has been continued. Then we will move to,
I'm going to take a quick recess. One quick one, we'll come back for lunch.
all right, we'll take a quick recess. All right, we'll continue with our Board of Pharmacy agenda. I think I'll move to agenda item 17 for executive report.
Thank you, Madam President. I will have the staff board. All right, while she's doing that, temporary licenses, registration, and address changes are in the board book. We do continue to meet with the healthcare boards, mostly related to Medi-Spas and what we're going to do with that. So we had a meeting yesterday, met with the health department, the governor's office was there with us, and looking about what the state's response is going to be to making sure that activities that happen at a Medi-Spa are done in a safe manner by licensed professionals when they're supposed to. So I expect that as I said, maybe I didn't present, I've presented in front of the interim healthcare commission for the legislators, sorry. And I think that there is likely to be some kind of bill that comes out of that. I did have to turn in potential bills for us to the governor's office through BNI. And I did that, and one of them was that bill, but it doesn't, just because I turned it in, doesn't mean the bill will be done by us. It might be done by somebody else. And there has been interest from the healthcare committee themselves to run a bill. So we'll just see what happens with the other two bills I turned in. One was related to the PMP and the federal grants. We saw, during the Trump administration that we did have a delay in grants, and that was, we were able to weather that particular storm, but over $1 million a year is spent through federal grants on the PMP integration for all the pharmacists, all the doctors, and all the other people that need to do the PMP check. So I think that there was a potential for a bill that would relate to that, and working with Mike and the staff on that right now. And then lastly, just be looking at fees, and there might be a bill about fees. And so we'll see what the math looks like and work with that. But all those, if we do run a bill, it would come in front of you. Like you would be making the decision to run a bill. I just, because of the timing, put a placeholder in for them, but said that I don't know if there'd be a bill or not. License activity report is in there, citations and fine. And then again, we're getting ready for the next legislative session that starts in February of next year. So just getting all our ducks in a row for that. Been talking to all the people that we're supposed to talk to, ready for that. It was already gotten some legislators call and say, we'd like to do a bill about this. What do you think about it? So we'll just do the normal thing. We have Mike Hillary to help us with that. So with the finances, we had our quarterly meeting with Adam. So he's seeing these for the first time. I think we're still on target for meeting everything that we said. I think payroll will be, again, because we have some open positions, payroll will be depressed compared to what we budgeted. And I think that we'll be interested to get the next 2 months so we can close the year. So I'll spend a little bit more time on the finances in the September meeting, probably just closing up the end of the year. And our other budgets were, you've passed your other budget and we're moving towards that. So I'll pause for any questions.
No questions. Thank you.
One more I should tell you is, we are, and you guys know this already, but I'll just put it on the record. Our lease is up February of next year. So we're actively looking for a lease. Any lease would go through Buildings and Grounds and be approved by the Board of Examiners. So we're just trying to find the right place that they will approve and has the necessary things we need to operate the board. And that's in Vegas. Thank you.
Right, very good. Thank you. All right, next we'll move to General Counsel's report.
Greg Camp for the record. The only thing I need to report is the petition for judicial review that's filed by Bernard Brooks has been submitted to the court for this decision without oral arguments. So we'll just wait to hear it before.
Thank you.
And that I didn't have anything. I would note that I'm retiring effective July 1. So
Well, we don't know for sure. We're not sure, because even in this meeting, he said we'll get to this later, so I don't know what he was talking about when he said that. But I do want to recognize Greg and his service to us, and he's been a great person to work alongside. And we'll miss him, but he's put his time in and he deserves to get to retire. So this will be his last meeting, and I'll make it official under your report that Laura Tucker will be the senior general counsel moving forward. And we've already hired a new attorney that will be located in Reno, that will be a general counsel for us. So Greg, really do appreciate your service. Glad that the last bit of it was your best part of your service, and it was at the Board of Pharmacy.
Mr. Zanino, thank you for your service and congratulations on your upcoming retirement.
Thank you.
All right.
You can just break, go to the restroom.
Well, should we break for lunch or?
If you should break for lunch.
Break for lunch?
Wash your hands, go to the restroom, and then we'll have lunch ready for you.
Okay, great. And we'll reconvene at 1 o'clock. Thank you. All right, welcome back to the Nevada State Board of Pharmacy meeting. I'm going to start by inviting one of our student representatives to come forward and to introduce their program. Yeah, don't be shy. Come on up to the mic. Oh, you don't have to come here. Yeah, to the mic. Yes, yes. You want to sit at the table and then in the microphone? Yes.
Yeah.
Yes, you got it. Hey, welcome.
So, good afternoon, everybody. My name is Martin. I'm enrolled in Pima Medical Institute, currently in the pharmacy technician program, as well as the rest of my class. Yeah, I just want to say thank you so much for having us here. We are very passionate about this career area. And yeah, me as well. I do plan on becoming a hazardous compound or compounder in the future. Yeah, thank you. Thank you.
Oh, great. Welcome, Martin, and your classmates. It's nice to have you here, and we're glad that you're passionate about your future career choice. So thanks for participating today, and thanks for the introduction.
Thank you guys as well.
Madam President, Dave Weiss for the, I have one question for Todd, just as
Yes.
housekeeping. Related to Adam pointing out the $1,000 discrepancy in the minutes. Todd, do we need a motion to change that, or is that a typo that the staff can just change? Please direct us and then we'll do. Please.
This is Senior Dad Todd Weiss. For something like that, we just want to announce on the record that we're making that change. No revote is necessary.
Thank you, Todd.
Great, thank you. Okay, we're going to continue with our agenda. Our next agenda item will be 5H for PharMerica. So if we have representatives, please come forward.
Hi, Madam President, Lynn Biggs on behalf of PharMerica. Just as a point of procedure, are we going to take the other two agenda items first before PharMerica? I believe that was items. The Camilla Kim matters.
So I'd like to take PharMerica first. Yes. All right, I'll turn it over to Mr. Zanino.
Thank you, Madam President. For the record, Greg Zanino prosecuting this matter on behalf of board staff. This is case number 24370 PHN, Nevada State Board of Pharmacy versus PharMerica. The first amended notice of intended action and accusation begins at page 2346 of your board book. We're having a contested hearing on this matter today, and I think my opposing counsel, Lynn Beggs, has graciously agreed to stipulate to the admissibility of exhibits. So I've got exhibits 1 through 5 here, and then I think Darlene, you may have to distribute exhibits 1 through 5 via PDF to the board members who are on Zoom. My colleague Laura Tucker to pass these out.
Ms. Beggs, do you have copies?
I have them digitally.
Lynn, if you need a paper copy, we've got plenty.
If we could, just so witnesses can refer to it. That
Definitely, yeah.
So I will ask even though Lynn is stipulated to the admissibility, I will ask a couple of witnesses to kind of comment on the exhibits and explain. They're not entirely self-explanatory, so you may need some explanation. So I intend to call two witnesses. One is Donna Fisher, and she'll be appearing by Zoom. And then investigator Monica Seghetti is here, and she'll be testifying in person. And I think Ms. Beggs may have a couple of witnesses that she intends to call as well. Is that right, Lynn?
Correct, I have two witnesses. And just for point of clarification, we're here to present solely on Pharmaerica and not Camilla Kim for the purposes of the contested hearing. Correct.
So I had not planned to make an opening statement just because I think we wanted to get through this as quickly as we can. But I mean, if Ms. Beggs has an opening statement, that's fine. She's
Ms. Beggs?
Just ever so briefly, so we are here on the first amended complaint. There are two counts related specifically to Pharmaerica. Just for the sake of streamlining the procedure today, and we'll certainly go through this through the testimony. Pharmaerica does not contest that there was a data entry error in the case, and that did lead to the prescription that will be presented today being improperly seized, the patient not getting the medication. So I just want to be clear on the record that we're not here on that point of contention today. So, hopefully that can streamline things. Our biggest issue today is the allegations related to inclusion and the data entry that took place in the Kentucky facility. So we'll be presenting information on that issue today.
Mr. Zanino, you're.
So I had intended to offer some testimony on the data entry issue. And I think that's just for the purpose of establishing that there were certain circumstances. I mean, a data entry mistake under some circumstances may or may not be unprofessional conduct. I think in this case it is. And I think the circumstances and the facts are important. So I had intended to cover that, although not at great length. My first witness, as I mentioned, who I would like to call is Donna Fisher. And I think she's should be available on Zoom.
Donna, raise your hand. Donna Fisher, if you're on the line, if you can raise your hand or hit *9 on your phone if you're on a phone, and we'll unmute you. Not seeing her, Greg. Do you want to have Laura try to get a hold of her?
I will. I sent her a text, and I can start with investigator Monica Seghetti.
And just provide the cell phone number to Laura, and she'll contact her and tell her that we're waiting on her.
Okay. Monica, will you take the witness stand?
Good afternoon. Hi, Monica. If you could state your full name for the record.
Monica Seghetti.
Hey, Ms. Seghetti, do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Thank you.
Investigator Seghetti, can you just tell me a little bit about yourself? You're an investigator for the Board of Pharmacy, correct?
Yes, I'm an investigator for the Board of Pharmacy. Been here for almost 6 years.
And before that, you were an FBI agent, is that correct?
Yes, I was an agent for the FBI for 30 years.
So did you investigate the case that's currently pending here? It's case number 24370 involving Pharmaerica.
I did.
And you opened the investigation in response to a complaint by Donna Fisher, is that correct?
Yes.
What was the nature of her complaint?
Donna Fisher's mother, Diane Phillips, was in a senior living facility in Sparks, Nevada. The senior living facility was Morningstar. And while she was in that facility, she did not receive her prescription for levothyroxine for a 3-month period, which ultimately ended her up in the ER, or actually the ICU at Renown for about 8 days.
Let me ask you, did you, in the course of your investigation, did you interview a number of witnesses?
I did.
And let me ask you, who, did you interview Dr. John Watson?
I did.
Okay, can you tell me why you interviewed Dr. Watson?
Dr. Watson is her primary care physician. And he's the physician who prescribed her the levothyroxine.
That was Diane Fisher's physician, correct?
Diane Phillips.
Excuse me. And did you ask Dr. Watson for medical records related to Diane Phillips?
Did.
I'm going to ask you to review exhibit number 5. Do you have a copy of exhibit number 5?
Lynn gave me one. Is that okay?
Thank you, Lynn. So let me ask you to review that. Do you recognize that?
Yes.
What is that?
This is an official request for records that I sent to Mr. Watson. I first had a phone conversation with him and asked for specific records, and then followed it up with this official letter.
So I'll move to admit exhibit 5. We haven't already done that, I think.
Oh,
Move to admit exhibit 5. I mean,
yeah, so I haven't admitted any of the exhibits, but they're both agreed upon. So do we admit them or?
maybe just admit 1 through 5 altogether.
And just for Lynn, just, you don't have any opposition?
Yeah.
No, I stipulate to exhibits 1 through 5.
Sure, for the record. That's.
Thank you. So exhibits 1 through 5 will be admitted.
So you, exhibit 5 indicates that you specifically asked Dr. Watson for a copy of the electronic prescription that he wrote for Diane Phillips.
Correct.
That was a prescription that he wrote on May 6th, 2024. Is that right?
Yes.
Let me ask you to review exhibit 4 if you have it. If not, I can give you a copy. So I will first ask you to turn, there's a cover page, and then if you would turn to page 1. This looks like a transmission email from Dr. Watson to you, correct?
Yes, it is.
It's like he included in that page 2. You see page 2?
Yes.
What is page 2?
Page 2 is a screenshot of the electronic prescription that he sent to PharMerica. He was unable to print me a copy, so he took a screenshot instead and emailed this to me.
Okay, and this is a little bit hard to read because it's a screenshot. But I understand that you've read it, correct? And you can.
I did bring my handy magnifying glass so I can read it.
So what was the date of the prescription that was issued?
March 6th of 2024.
And it was written for, did you confirm that this is the prescription that was written for Diane Phillips?
Yes.
And it was written for levothyroxine, correct?
Correct.
What was the course of treatment with it? I mean,
It was written for 90 tabs of 88 microgram levothyroxine, 1 pill to be taken every day for 90 days with 3 refills. So the prescription was to last her 1 full year.
Let me ask you to turn to the next page 3 of the exhibit 4. It looks like this is an email, a transmission email from Dr. Watson's. Is that from Dr. Watson's medical assistant?
Yes,
Hannick?
medical assistant is Stacy Hannick.
Okay.
At his request, she sent this to me.
So
Okay.
So, ask you to look at the remaining pages, pages 4 through 11. And you've reviewed these previously, right?
Yeah.
So let me ask you about, so that, are these, so is this a record of, Diane Phillips' visit to Dr. Watson on March 6th, 2024?
Yes, it was her annual wellness visit.
And then there's another record that relates to a visit on September 9th, 2024?
Right.
Do you understand? Why is there a second visit on 9/9/24 to your knowledge?
The 9/9 visit is her follow-up exam after she was released from the ICU with Renown.
Okay. So there's one more thing on the prescription that I wanted to ask you about. Back to page 2 of Exhibit 4. This indicates in one of the fields, the word maintenance.
Yes.
Did you inquire about what that means, maintenance?
Yes.
Like what?
The levothyroxine is a maintenance medication that Ms. Phillips will have to take for the duration of her life.
Did you, during your investigation, also interview an individual by the name of Mark Johnston?
Did.
And did you conduct that interview by telephone or did you conduct it in person?
I had multiple interviews with him. The initial one was in person at his office at PharMerica.
Okay, what, if anything, did he tell you about his role or position with PharMerica?
He's the director of pharmacy for the Reno PharMerica location on Longley Lane.
And so did you ask him about PharMerica's processes for filling or dispensing prescriptions from that location on Longley Lane?
I did. I wanted to understand how the relationship worked because Ms. Phillips' daughter, Donna Fisher, told me that they had entered into a prescription maintenance program with PharMerica, and I was not quite familiar with what that was. So I met with him in person to get a full understanding of what the prescription maintenance program was.
Okay. And what if anything did he tell you about PharMerica's kind of internal processes for filling prescriptions?
All PharMerica patients that are in a senior living care facility, all of the intake of their prescriptions are handled by PharMerica in Louisville, Kentucky.
So explain to me, can you elaborate? What did he tell you what intake means? What occurs?
When the electronic
intake
prescription is originally received by PharMerica, if it is for a patient that's in a senior care facility, it goes to their senior living unit in Louisville, Kentucky. Then the data is entered at their office, their facility in Louisville. And then from there, once the data is entered, it's sent to whatever portion of the country is relative for that patient. So in this case, it was sent to Reno.
The data is
reviewed and verified by a pharmacist in Reno.
okay. So did you ask Dr. Johnston for any records related to the prescription that was issued on March 6, 2024 by Dr. Watson?
Yes, that was Exhibit 4.
I think Exhibit 3. So I'll ask you to look at Exhibit 3.
Oh, you're Mr. Johnston, not, I thought I heard you say Dr. Watson. I apologize. Yes. Exhibit 3 is the records that were provided by Mark Johnston.
So please look at page 1 of Exhibit 3. This is an email. It purports to be an email from Dr. Johnston, Mark Johnston to you. Is that correct?
Correct.
And there's some writing in black text and there's some writing in red text. Can you explain that? Why some is in red and some is in black?
After my meeting with Mr. Johnston, I sent him an official request for records. They provided the records. And then after reviewing the records, I had these additional questions, which I emailed him. My question to him is in black. His response is in red.
Let me ask you to turn to page 2. Do you know what page 2 is?
Yes.
What is that?
It's the screenshot of the data entry in Louisville, Kentucky.
And this, it looks like, was produced by Ashley Vest
Yes.
in response to a request from Mark Johnston, right?
Yeah.
What did you inquire of either Ashley Vest or Mark Johnston about this duration code that appears in the upper right-hand corner? It says X90D.
Yes.
So who did you talk to
So
about that?
Vest is the PIC for the Louisville, Kentucky location. She provided these records to Mr. Johnston. And then when I had questions to make sure I had a clear understanding of what this record was, I reviewed the records with Ashley Vest over the telephone, and she explained to me what this duration field meant.
So what is the significance of that duration field, X90D?
So the duration field is not a mandatory field. It can be left blank. And as Ashley Vest explained to me in this case, that should have been left blank. The duration field is used for short-term medications. For example, if you were prescribed an antibiotic for 30 days, then the duration would end after 30 days. In this case, since this is a maintenance medication, the duration field should have been left blank.
And had the duration field been left blank, would the prescription have been automatically refilled to your understanding?
Since it was written with 3 refills, it would have been, in PharMerica terminology, cycle filled, which is the same thing as an autofill. It would have been automatically refilled at the end of 90 days.
But is it your understanding that this code was entered in Louisville, Kentucky, was entered into the system in Louisville, Kentucky?
Correct, by a
Did you-
pharmacy tech in Louisville.
So you inquired about who entered it
I
in
did,
pharmacy technician?
the pharmacy technician.
What, if anything, did you ask Mark Johnston or Ashley Vest about the operation in Louisville? How many pharmacists did you ask? How many pharmacists are there? How many techs are there? Did you kind of cover those issues?
I
Or
don't think I specifically asked him those questions.
let me ask you. I think to turn to page number 4, and I'll ask you to just review quickly pages 4 through 7. There. So what do these show?
So these show that the prescription was being dispensed every 30 days. So I was confused because the prescription was written for 90 days with 3 refills. So I didn't understand why it was being filled every 30 days. So I had a conversation with Ashley Vest, the PIC in Kentucky. Why? Because these were produced from Kentucky, I believe. But I asked her, why was the medication being dispensed every 30 days rather than 90 days?
And what was her response?
That was at the request of Morningstar, the senior care facility, because according to Morningstar, it's easier for them to manage a batch of 30 tablets and 90 tablets. So at their request, they wanted the medication dispensed every 30 days rather than every 90 days.
So let me ask you to look back again at page 1 of Exhibit 3. The red text that appears at the top of that email. Does this also appear to be a response to your questions about the 30-day dispensing?
Yes.
And so is it your understanding that that PharMerica and Morningstar kind of mutually agreed to have these tablets dispensed in 30-day increments as opposed to a 90-day supply?
Yes.
So let me ask you, did you interview the pharmacist who actually verified the data that was entered in Kentucky?
I did.
And who was that?
It was Camilla Kim.
Where did you conduct that interview?
I conducted that interview over the phone while she was at work, and I wanted to make sure she had access to these records so she could review the records while I was speaking with her on the phone.
So did you ask her specifically about her role or position with PharMerica?
Yes, she was a staff pharmacist there at the time.
And that was at the location on Longley Lane?
Location here in Reno on Longley.
Did she acknowledge that she was the person who verified that prescription in question?
Yes, she did.
So did you ask her why the prescription had not been automatically refilled after 90 days?
She did.
What was her response?
She explained that because the duration field was populated with X90D, that is a communication by the computer that the prescription is going to end after 90 days. So it will not automatically refill. And she also acknowledged it was her responsibility, that she should have noticed that, knowing that levothyroxine is a maintenance medication. She should have deleted that field.
Did you ask her about whether there were any pharmacy technicians in the Longley Lane location that were there to assist her or help her with it?
I don't recall if I asked that.
Those were all the questions I had for Investigator Sketty.
Ms. Beggs?
Thank you. Good afternoon, Investigator Sketty. Let me just pick up on your interview with Ms. Kim or Dr. Kim. Did you ask Dr. Kim regarding if she had supervisory duties of any pharmacy techs for PharMerica?
I don't believe I did. In Reno?
Anywhere.
Yeah, I don't believe that I did. I mean, it's automatic that pharmacists oversee pharmacy technicians. I didn't ask her how many she had.
Were there pharmacy technicians in Reno?
I believe there were. I just don't know how many.
And in regard to I'm just making sure I get that. May I see exhibit 3? Thank you. So you indicated that part of the email, and then you had a conversation with Ashley Vest, who was the PIC in the Kentucky facility.
Correct.
And Dr. Vest is actually a Nevada registered pharmacist, correct?
Yes, she is.
And she was actively registered at that time?
I believe so, yes.
And you indicated that you did not ask her about staffing at the Kentucky facility?
I don't believe I did, no.
And going back to the records that were received from Dr. Watson, were any records requested from Renown Hospital itself?
I don't believe so, no.
And so in looking at, let me share it with you, Exhibit 4, I'm looking at page, what's been date stamped is page 4. This would be the 9/9/24 clinical note. When you reviewed that, were there any references to a recent hospital stay at Renown?
Don't know off the top of my head without actually reviewing it again. I know that this was after talking with Miss Phillips' daughter, Donna Fisher. She took her to this visit as a result of her being in Renown. And it was kind of the diagnosis that Dr. Watson made, what she had suffered from. I don't know off the top of my head if there's a reference to her being in Renown.
Okay. And during the course of your investigation, did you request any additional records from the Kentucky facility?
I did not.
Or from corporate PharMerica offices?
I did not.
Thank you. I don't believe I have anything further for Ms. Getty.
No redirect from me.
Board, any questions for Ms. Sketty? Okay, thank you, Ms. Sketty. All right, Mr. Zanino?
So my next witness, and I believe she's on now, is Donna Fisher. Donna, are you there?
Yes, can you hear me?
Yes, we can hear you. So for the record, could you state your full name, please?
Yes, Donna Fisher.
Ms. Fisher, I'm going to swear you in. If you could join me in raising your right hand.
Okay.
Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes, I do.
Great, thank you.
Ms. Fisher, I understand that you currently reside in the Reno Sparks area, is that right?
Yes,
Okay. How long have you lived in the area?
I have lived in the area for 5 years.
What is your profession or occupation?
Registered nurse
So, how long have you been practicing as a registered nurse?
for 24 years.
And you think you're licensed by the state of Nevada as well as the state of California, is that right?
Yes.
Okay. And where do you currently work?
Currently, I work at Barton Memorial Hospital in South Lake Tahoe.
And you are a delivery room nurse, is that right?
Yeah, well, labor and delivery and postpartum, yes.
Let me ask you about your mother. Do you have a mother named Diane Phillips?
Yes.
How old is your mother?
She is 89.
So does your mother currently reside in an assisted living facility?
Yes.
Where is that?
Currently, she is in a assisted living facility called Kylie Ranch Senior Living.
Let me ask you, does your mom have cognitive issues?
Yes.
Does that involve like short-term memory loss?
Yeah, she's been diagnosed with dementia.
Okay. Do you have any like siblings that can help you take care of your mother?
I have a brother, but he lives in Virginia, so it's just me and my two girls, my two children, adult children. So, but it's mostly me.
So I think your mother has given you a durable power of attorney for healthcare. Is that right?
Yes, general and medical and health.
So
Yes.
So you make medical decisions, or at least you have in the last 5 years made medical decisions on her behalf.
Yes.
You also make financial decisions for her.
Yes. Yeah. She's
so
not
when-
able to do any of that anymore.
So let me ask you, when did you first notice that your mom was experiencing short-term memory loss?
Well, I moved her. She was living by herself in Southern California, and I moved her here in 2020. And she was in an independent facility for 3 years, and probably the last year of that, I noticed a big decline in her being able to take care of herself independently. So probably 3 years ago, I noticed a big, well, you know, it was subtle, but I noticed that she wasn't able to take care of herself by, without help.
Were you at that time managing her medications for her?
Yes, I was helping her, and quickly realized that she needed more than the help that I could give. I was putting them in the AM, PM little boxes and making sure that they were her medications were filled, and I was picking them up because she wasn't driving anymore. And I was calling her every day, if not there every day, making sure she took them. And that worked for a couple years, and then all of a sudden it didn't.
So did you at some point decide to move her into an assisted living facility?
Yes, that was when I decided I needed help helping her take her medication because I worked, so I couldn't be there every day. So that's when I and my brother, we both decided it was time to put her in assisted living to help with everything, but especially the medication.
So let me ask, did you move at that time? Did you move her into the Morningstar facility in Sparks?
Yes.
And was it your understanding that Morningstar would manage your mother's medication?
Yes.
For her?
Yeah, we in the admission process, we went over all of that and all the medications, and we transferred everything over. Yes.
Okay, so I previously, I think, emailed to you some exhibits that I intended to use today, and I have in front of me. I emailed you one labeled Exhibit 1. There's a cover page, and it says Exhibit 1 on it. You have that?
I do. Is that the physician's plan of care or the electronic order?
So page one, it's labeled pharmacy and medication program consent.
Yeah, I have that.
Okay. So let me ask you, is that the agreement that either you or your mother signed with Morningstar concerning medication management for your mother?
Yes. Yeah, we had the choice of them controlling the medication or not, and I chose to have them control it. Yeah.
Okay. Let me ask you, do you have that there's a page 2 and a page 3 for
Yes.
that document as well? Is that a document that you or your mother signed authorizing, it looks like in this case, PharMerica to debit your mother's account for the cost of the medication that wasn't reimbursed by Medicare?
Yes.
Okay.
Yeah.
So Lisa, was your understanding at that point that your mother's medication needs would be satisfied by Morningstar and or PharMerica, right?
Correct.
Okay. Let me ask you about your mother's like visits with her physician. Who was her physician during the time that she was at Morningstar? Dr. John Watson?
Yes.
Okay. And did she visit him routinely, annually? Can you just describe that for me?
Yeah, we had she always had her annual visits for labs and her care. And then if anything came up along the way, we would make appointments. But she'd been doing well, and we would just go in every year for her annual visit.
Okay, and so did she, to your recollection, have an appointment with Dr. Watson on March 6th, 2024?
Yes, that was her annual visit.
And did you accompany her to that visit?
Yes.
And what was the kind of the outcome of that? I mean, generally what was discussed?
It was a general, like, they do a cognitive kind of screening, and she doesn't ever pass those, but it's something that they do every year. And then they do all her vitals, and they check all her labs, and then he issues, and we go over all the medications. And at that appointment, he didn't change anything, so he just kept her on the same medications.
So was one of the medications that she was taking levothyroxine?
Yes. 88 micrograms.
Okay, and he prescribed he issued another or a new prescription for levothyroxine at that time? Yes.
Yeah.
Okay. And
it wasn't new, it was just a continuation.
Okay, but what was the course of treatment, according to the prescription that he issued, if you recall?
One daily in the morning.
And Paul, did that prescription call for a 90-day supply with 3 refills, to your recollection?
He sent the prescription directly to the pharmacy, and I don't know what exactly that was.
That's fine. I don't want you to speculate.
Okay.
Let me ask you to review Exhibit 2. Do you have that? I think I emailed that to you.
Yes. Yeah.
So let me ask you there's a cover page, and then there are 2 pages. Let me ask you to look at page 2. What do you recognize that? What is that?
Is that the I don't know. I'd have to pull up my email to see what was page 2. Is that the electronic order?
The electronic new order. Was that a document that you requested from PharMerica?
No.
Or from Morningstar?
No, I got a copy of this from Morningstar.
Okay, so Morningstar provided that to you.
Yes.
And this appears to me to be a summary of Dr. Watson's prescription? Is that what you understand it to be? Oh,
Yeah, that's what it looks like to me.
let me ask you, okay, between like from beginning March 6, 2024, how often did you visit your mother at Morningstar?
At least 4 days a week on my days off. I've seen my mom every day on my days off, unless I'm on vacation since she moved here in 2020. Just my normal routine with her.
So you work 3 days a week and then you have 4 days off. Is that fair to say? Okay. So at some point, did you notice that your mother's health was declining?
Yes, it was gradual. Morningstar called me a couple times. And honestly, my first thought was that she wasn't sleeping well. But yeah, she had, she just was kind of she was sleeping more than normal and she was moving slower than normal. And then we noticed some sores on her legs and I did notice a few things. That's what initiated my call to my brother, who also didn't like the sound of how things were seeming. We didn't know what was going on, but he decided to fly out, and that's when we took her to the hospital.
So was there a time when she fell and injured herself?
Yes, she did fall in July, and the Morningstar called me and said that the ambulance had already taken her to the hospital. Nothing, she had some skin tears and then they brought her back. I was at work, but they said, so they called to tell me that she had fallen and she'd been to the hospital and come back. So when I got off work, I just went straight there and her arm was all wrapped up, but she didn't break anything. But yeah, she did fall.
So it's like after July, there came another time when you made a decision to transport her to the hospital, right? Or have her transported to the hospital?
We took her to the hospital. So she was having a lot of just this sleep, she was sleeping mid eating in her meals, which was unusual. And she was having to stop much more frequently. She'd take a couple steps. She walks with a walker, but she was taking a couple steps and having to stop. And the staff said that they really noticed it a lot more frequently. And then, she was and then she started getting a lot of edema on her lower legs. And so we were getting compression socks and we were keeping her legs elevated, and we bought a sleep chair for her. And we were going through all these steps, not sure what was causing all this. And then I made an appointment with Dr. Watson because I was concerned that maybe she was entering a stage in her life where she needed a wheelchair. I wasn't sure. So I had made an appointment with him to go over this decline that I was noticing. But what made us take her to the hospital was these sores. She started getting these blisters on her legs, and a little small dime size, got huge, in one day. And that was actually when my brother came out, and we just said, we're not going to wait for her appointment. We're just going to take her to the hospital. But that's what ended up taking her to the hospital, was those blisters on her legs and the swelling. And that's when we found out. We didn't know, but then on the way to the hospital at Morningstar, the pharmacy tech, I asked her for a printout of all my mom's medication so I could take with me. And that's when she told me that she wasn't taking her medication, that her thyroid medication.
So who told you that? Let me ask you, who told you that your mother wasn't taking her thyroid medication?
It was Kathy. Her name is Kathy. And she was I knew her because I was there a lot, but she was I don't know what her title is, but she dispenses the medications. I think the medication tech there.
Did you ask her why your mother was not taking her medication?
I did.
What was
Yeah,
the
because that
response?
was the response was, I don't know. And my next question was, well, how come you didn't tell me? And that response was, we're not obligated to tell you. And we just scooped up mom and took her to the hospital, and I didn't get into it at the time, but because I didn't, yeah. So and then we went to the hospital, and I told them when we got there that I had just found out this information. So they ran a thyroid panel, and that's when we found out that. And then while my mom was at the hospital, because that admission was a week, I was making phone calls back to Morningstar, and I found out more information through texts with the nurse there, of how long, ago that they stopped giving it to her. And so I was getting more and more information as my mom was in the hospital, but I didn't know at the time.
Okay, let me ask you to refer to Exhibit 2 again.
Okay.
There are a couple of like business cards,
Oh, mm-hmm.
right? You see those?
Yeah.
One is a business card, Marshanta Masong, and another one is Sal Gomez Orozco. Who are those people?
Sal at the time was the director there. I made numerous calls to him while my mom was admitted in the hospital, and he never ever returned my call. But Marshanta did return my call, and she was I don't think she's a registered nurse, but I think her title is a LPN, and she's the wellness director for Morningstar in Sparks. So, and I know it was a fairly new position for her. I think the beginning of that year, she took over from somebody else.
So at some point, did either Sal or Marshanta agree to answer your questions about your mother's medication management?
When I couldn't get a hold of Sal and he wouldn't call me back, and Marshanta was at least calling me back and returning my texts, I told her that I wanted, before my mom got released from the hospital, I really needed to come in and talk to them to find out what happened and why and all that. And she said she would meet me, and we picked a time and a day. And I said, well, I need Sal to be there also. And she said, okay, I'll make sure he's there too. So he showed up. He was there when I went back and met with them.
And did they have an explanation for as to why they had stopped giving your mother her medication?
Yeah, Sal handed me a copy of the electronic prescription. I'm not sure what exhibit number it is, but it's the electronic order. And he said that Dr. Watson did not order the prescription for more than 90 days, and they weren't obligated to give her medication after it was discontinued. And so my response was, so you're saying this is Dr. Watson's fault? I'm still not sure what happened. So I was just trying to figure it all out myself. And he said, yeah, that's correct. And then we asked for a copy of that, and he gave it to us, and then we left.
In the copy, it confirms that Dr. Watson ordered 3 refills, correct?
Correct.
Yeah, and that would have lasted your mother for a full year. Is that correct?
Yes. Yeah. And Dr. Watson's been her doctor ever since she moved here in 2020. So it's been the same prescription all those years.
So how long, to your recollection, has your mom suffered from hypothyroidism?
I don't know when the exact. I could probably find out from her doctor, and she used to be in Lancaster, California. But it's as long as I can remember as going to visit. She'd always have her thyroid medication on the kitchen counter, and she was always good about going to her doctor's appointments. And as long as I can remember, she's been on thyroid, because it's always been kind of a family thing too. I'm on it, my kids are on it. So yeah, I don't know when, but I know it's been a while.
So let me ask you, when your mother was released from the hospital,
Yes.
August or early September.
September.
Did you have a follow-up visit with Dr. Watson?
Yes.
And did you accompany her to that visit?
Yes.
And what was Dr. Watson's assessment at that time?
He was very concerned about what happened and worried, and he pulled up all the information and he ordered more labs and then repeat labs. I think the first few months we had repeat labs like every 6 weeks, but he kept her on the higher level of well, she was on IV levothyroxine or Synthroid in the hospital, and then he put her on and kept her on the 100. She had been on 88, but he kept her on the 100 until just recently he dropped it back down to 88. But it was just a follow-up, making sure she was okay, and then getting repeat labs. Thyroid's one of those things where you have to kind of repeat labs frequently just to make sure the levels are staying okay. And she's bounced back.
So currently, how is her health?
Currently,
Improved?
currently she has improved. She's back to her 88 micrograms of levothyroxine. Yeah. Cognitively, hasn't improved, but physically she hasn't had any incidents in the last year, so that's good.
Don, I want to thank you so much for appearing today. I don't have any further questions for you, but I think my opposing counsel, Lynn Beggs, may have some questions for you. So.
Okay.
Good afternoon, Ms. Fisher.
Good afternoon.
I don't have any follow-up questions for you, but thank you so much for your participation today.
Okay, thank you very much for your time.
Board members, any questions for Ms. Fisher? Okay, no other questions for you. Thank you so much for your appearance today.
Thank you.
Okay, Mr. Zanino, anything else?
With that, I rest my case.
All right, I'll turn it over to Ms. Beggs.
Thank you. We would call our first witness Scott Clark.
Mr. Clark, could you state your full name for the record?
Scott Clark.
Do you swear that the testimony that you're about to provide will be both truthful and complete? Thank you.
Good afternoon, Mr. Clark. Can you tell me, who are you currently employed by?
I'm employed by Far America.
And what is your position there?
I'm the Chief Clinical Officer.
And in your position as Chief Clinical Officer, what are your general duties?
I'm responsible for clinical education, clinical programs, clinical operations.
And do those clinical operations include regulatory compliance to an extent?
Yes.
And how long have you been in the position?
8 months.
Yeah. And can you just very briefly give us a kind of high level overview of what PharMerica is and what PharMerica does?
Yes. So PharMerica has pharmacies throughout the United States, 2 of which are located here in Nevada. And these pharmacies serve some of the state's most vulnerable populations, including assisted living facilities or residents in assisted living facilities, skilled nursing facilities, and group homes. Sorry. The patients we serve are medically complex, often with multiple chronic conditions and cognitive impairment. And they typically receive 10 or more medications. And because of this complexity, our model is designed to ensure strong clinical oversight, support medication safety, and consistent delivery of care.
Is PharMerica a retail pharmacy where a patient would come into the pharmacy?
No, these are closed door pharmacies.
And who do you service? Do you service just long-term care?
Predominantly long-term care, assisted living, skilled nursing, and group homes. Yes.
Now, you have pharmacies in the state of Nevada?
Yes, we have 2 locations in Nevada.
And at the time of the incidents and these questions, do you have other facilities within the country that facilitate data entry?
At this time, the Kentucky pharmacy was doing data entry.
And you said at this time, is the Kentucky pharmacy now closed?
Yes, it is closed.
And is part of your duties as Chief Clinical Officer, and you indicated that you are also involved in compliance provisions, is that ensuring that proper licensure of the pharmacy and its employees, if necessary, is obtained?
Yes, I do have oversight.
And was the Kentucky facility a licensed non-resident pharmacy?
The Kentucky Pharmacy was a licensed non-resident pharmacy in Nevada.
The Kentucky Pharmacy does currently have an active license, but is not operational. Is that
Correct.
now, at the Kentucky Pharmacy, and did you have a Nevada licensed pharmacist as PIT?
We had a Nevada licensed pharmacist on staff. I'm not sure if she served in the PIT.
And did you also have pharmacy technicians that were employed in Kentucky?
Yes, and they were licensed in Kentucky.
They were licensed in. Now, does PharMerica have a shared services agreement between its pharmacies?
The two pharmacies are under common ownership.
And do they share a data, do they share a shared computer system consistent with Nevada's shared services agreement?
Correct. They have a common database that is shared between the facilities, compliance with NAC 639.929.
And as far as your pharmacies being in compliance with licensure, let me rephrase that, as far as supervisory duties, who is responsible to supervise the Kentucky pharmacy techs?
The Kentucky pharmacies located in Kentucky and the Nevada licensed pharmacists in Kentucky.
I couldn't hear that. Could you?
I was gonna
say
say,
that again?
yeah, if you could speak closer to the microphone, it's hard to hear you.
So the Kentucky technicians are supervised by the pharmacists in Kentucky that are licensed in Kentucky and the Nevada licensed pharmacists located in Kentucky in our pharmacy.
So you had a Nevada licensed pharmacist supervising any pharmacy tech touching a Nevada prescription.
Correct. Yeah, that is a requirement of the statutes in Nevada.
And that's pursuant to NRS 639.2328.
Correct.
Sorry, I missed that last part. So you said the Nevada pharmacists are responsible for managing the Kentucky technicians that touch the prescription?
The Kentucky licensed pharmacists that are also licensed in Nevada are responsible.
Okay, see.
Just for the record, where are the pharmacists located?
The pharmacists are located in Kentucky.
Okay.
So just to clear up the model, so the prescriber or healthcare provider issues a prescription for a patient, it would go to the Reno pharmacy. Reno pharmacy is responsible for the prescription. The data entry, only the data entry, typing the prescription into the pharmacy, into the common database was done in a Kentucky licensed pharmacy and a Nevada licensed pharmacy in Louisville, Kentucky. That pharmacy was licensed in both states. And the pharmacy had a Nevada licensed pharmacist on staff who was responsible for the acts of errors and omission that's outlined in the rules. The only piece of the prescription process that was performed in Kentucky was the data entry. The technician entered that in from looking at an image of the prescription. From there, the pharmacist in Nevada would perform all the other functions. They would perform the prescription verification, ensure the prescription was entered accurately, make sure the prescription was legitimate, it's clinically appropriate, perform the DUR, and the Nevada pharmacy would also do the dispensing. The only act of the process performed in Kentucky was the data entry by the technician.
Thanks, Lynn. Sorry, we just didn't understand what he was saying. So.
No, that works. And Mr. Clark, to your knowledge, was the Kentucky facility when operational a dispensing facility?
No, it was a non-dispensing pharmacy.
And just to reiterate, the responsibility for verification and filling up the prescription is by the Nevada pharmacist in Nevada.
Correct.
Thank you. I have nothing further for Mr. Clark. If Mr. Zanino has follow-up questions.
Mr. Clark, so you can confirm for me that in September of 2024, that the Longley Lane facility in Reno was dispensing the drugs to the residents of the Morningstar facility, correct?
That's my understanding, yes.
And there were pharmacy technicians in Kentucky performing the data entry for those prescriptions. How many pharmacy techs in Kentucky at the time?
I don't have the number. The next witness may be able to provide that, but I don't have the operational number.
Do you know how many pharmacists were in the Kentucky facility? Let me ask you about what, if anything, do you know about the facility on Longley Lane? How many pharmacists were was that pharmacy staffed with at any given point in time? The one in Reno?
Yeah, I do not know. I'll defer to the next witness who manages the operations.
So let me ask you, why did the Kentucky pharmacy close?
I think the business model for PharMerica changed and they decided not to continue that entry aspect from Kentucky.
How did the business model change? Can you elaborate?
I think the decision and the next witness may be able to explain more. My understanding is the model changed as they wanted to move that function back into the pharmacies, into the local pharmacies.
So the data entry currently is occurring for the Morningstar facility at the Longley Lane location. Is that your understanding?
I have the data in terms of where that's being performed today, or if it's being performed for Morningstar.
Okay. Why do you know why it was an initial decision to adopt this shared services model?
I was not with the company at the time the decision was made, but shared services is a very popular model in pharmacy practice, and there's numerous benefits to that type of model. I don't want to make assumptions, but the next witness may be able to specify more of the rationale for that.
What are the benefits to the shared services model?
Shared services models allows pharmacies to be more efficient, improve quality, be able to have business continuity if pharmacies close or people call out. You have a model where individuals and other pharmacies meeting the requirements of the state can do order entry, can do other aspects of the prescription process. It's a model that's been around for decades and was very vital during COVID to keep pharmacies open and keep medications dispensed to patients.
Let me ask you, are there cost savings associated with the shared services model?
There can be, because it makes it more efficient. Yes.
Those are all the questions I had.
Board members, questions for Mr. Clark?
I have a couple, Adam Port for the record. So Mr. Clark, you stated that the Nevada pharmacy and the Kentucky pharmacy are under common ownership?
Correct.
Okay, so any error of omission would be the responsibility of either pharmacy in that case?
Correct.
Okay. Do we know who the Nevada licensed pharmacy who is the pharmacist that verified the data entry on prescription number 343217 in this case?
Our next witness can answer that, Mr. Clark.
Great, thank you. I don't have any other questions.
Any other questions?
I just have one quick clarifying question. I just want to make sure I understood it correctly. You're stating that the data entry was the only portion of this prescription that was filled was done in Kentucky. The rest of it was verified
Correct.
by the licensed pharmacy in Nevada.
Correct.
Okay.
Thank you so much for your time.
Thank you.
Thank you. Our next witness would be Bill Dean.
Good afternoon.
Good afternoon.
If you could state your full name for the record.
Bill Dean.
Mr. Dean, if you could join me raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Thank you.
Mr. Dean, can you please state who is your employer?
PharMerica.
And what is your duty? What is your position with PharMerica?
I'm the chief pharmacy officer.
And how long have you been with PharMerica in that position?
7 years with the company and about 2.5 as chief pharmacy officer.
And what do your duties as chief pharmacy officer entail?
I run our field operations.
And does that include visiting your various pharmacy locations around the US?
Yes, ma'am. I make visits to our pharmacies.
And Mr. Dean, were you personally involved with the underlying case that's brought us here today?
No, not personally.
But you've reviewed the case and you're familiar with
I
it?
have.
And so as far as, can you, before we get into the details of this case, follow with what Mr. Clark was stating as far as how, at least at this time, which was 2024, the shared services agreement model was working for PharMerica?
At that time, we had a central order entry pharmacy in Louisville, Kentucky that typed prescriptions for assisted living facilities only. abroad. Specifically related to this in Nevada, out of Nevada.
I might need you, do you need him to move that just a little?
It would be helpful, yes.
I'm sorry.
So that's better. Thank you.
Okay.
And just to follow again on what Mr. Clark said, was the Kentucky facility a dispensing pharmacy?
No, it had no inventory. It was just a sea of cubes.
Was it, to your knowledge, was it a duly licensed non-resident Nevada pharmacy?
Yes, correct.
And at the time of this particular issue in 2024, do you know who the PIC was at the facility?
Yes, it was Renee Niergarten.
And to your knowledge, was Dr. Niergarten or is Dr. Niergarten a Nevada licensed pharmacist?
She was at that time.
And did she have any supervisory duties at the Kentucky facility?
Yes.
And what were those duties?
She was the PIC. She assisted in managing the tech staff
And
and the pharmacist staff there.
And so Dr. Niergarten would have supervised any pharmacy tech touching a Nevada prescription?
Correct.
And Mr. Dean, to your knowledge, approximately how many Nevada prescription would be processed, or at least the data entry portion processed at the Kentucky facility?
For Nevada, it was very small. I mean, give you a little bit of demographics. We service 54 long-term care facilities in Nevada, across Reno and Las Vegas. That represents about 3,000 patients and about 30,000 prescriptions a month, 360,000 scripts a year. So we had about 2 facilities in Nevada at that time, the Morningstar and Sparks. And I apologize, I don't remember the name of the other facility at that time in 2024. And at this time, we no longer service the Sparks facility for Morningstar.
Do you currently service any Nevada pharmacies?
But you have facilities?
Or let me rephrase that question. Do you currently have Nevada pharmacies that service long-term care facilities?
Yeah, we service 54 facilities in the state.
And so just to follow up on that, why so few prescriptions at the Kentucky facility?
Because it was limited to only typing orders for assisted living. It didn't type for our full set of business lines.
Now, in regard to this particular case, you're familiar that there was a data entry error.
Yes, they inadvertently put a stop date or 90-day stop on that prescription.
So after an electronic prescription is sent, or at the time was sent to the Kentucky facility, can you just walk us through the process of what would happen?
Yeah, let me clarify something. The script is owned by Reno, so it goes to Reno. The pharmacy in Louisville just accesses that through a common database to type the order. So they type the order and it is sent through workflow to pharmacist verification 1 to review the prescription, and then so on through the remaining steps in workflow.
And in this case, the data entry occurred in Kentucky, and then the prescription was basically then transmitted to the Reno facility?
It's not transmitted, it's just in the, in the workflow.
In the shared computer system?
Yeah, it's in the shared computer system. If you think about steps, it just goes through steps. So PV1 adjudication, and a label is printed, then it's filled, and then PV2. And then we have an extra process that's different than retail, where we place the medications in a tote that is then subsequently delivered by courier to the facility. So we have tote scanning. So just to help everybody understand long-term care a little bit.
And do those activities all occur at the local pharmacy where the prescription is being filled?
That they occur at the Reno pharmacy.
So in this
where it's
particular,
being filled, it is only order entry at Louisville at that time.
and in this particular case, do you know who the filling pharmacist was?
I mean, I'm probably gonna slaughter the name. I think the last name of the pharmacist was Kevin. Am I right? For the record.
You are correct for the record.
Sorry.
And as far as Dr. Kim's duties, then she would fill and verify all aspects of that prescription?
Yeah, she PV1'd it. So I mean, she did the clinical checks, she verified the prescription for accuracy, which includes all elements of the prescription. Drug, dose, quantity, directions, duration, prescriber, facility, patient, all the things.
So if there was an error in regard to the duration, it was Dr. Kim's duty to catch that,
Correct.
and she did not.
That's what we found out, yes, ma'am.
And Formerica does not dispute that Dr. Kim missed it.
No, it's a fact. There's no dispute.
I don't believe I have anything else for Mr. Dean at this time. Mr. Zanino?
Thank you, Mr. Dean. Tell me about the facility in Kentucky when it was operational in 2024. How many pharmacy techs were at that location?
It's been a minute, but I think it was about 40 at the time.
And how many pharmacists total?
5, I believe.
Were the pharmacists and the pharmacy technicians located in the same building?
Yes, sir. It was a room very similar to this with cubicles.
And so the pharmacy technicians in the Kentucky facility performed the data entry for the prescriptions that were sent to the Reno location. Is that correct?
Yes, sir.
What kind of supervision were the pharmacists performing in the Kentucky location during that time?
If you can imagine like rows of cubicles with technicians and pharmacists intermingled in those rows so that they could interact with each other. If a tech had a question or a pharmacist needed to give direction, that's how that would happen.
So were the pharmacists in Kentucky checking the data entry that was performed by the? No. Okay, they didn't do it yet.
They do not have, in this model, they did not have PV1 responsibilities for Nevada.
So to clarify or confirm that the pharmacist in the Reno location was responsible for checking the accuracy of the data entry. Is that right?
Yes, sir.
So how would the pharmacist in Reno do that? Just look at a screen?
Yeah, just like we do everywhere. Yeah.
Did the pharmacist in Reno have any interaction with the pharmacy technicians in Kentucky?
We have teams and where we can chat back and forth. And we also have everyone's extension. So you could just like hit 1, 2, 3 if that's where the tech was, who was assigned to your facilities. We have assignments, and so they could go right straight to the tech. And you can see the tech's initials and on the screen. So you knew that like if I was a tech, Bill Dean entered that prescription, they could contact me. So
to the extent that there was interaction between the Reno pharmacist and the pharmacy technician in Kentucky, that was done through electronic computer means?
Yes, sir. Yeah, but telephonic and through chat. Yes, sir.
Let me ask you, did the pharmacist in Reno have any pharmacy technicians in Reno that she was supervising?
Oh, yes, sir. Yes, sir.
So how many pharmacy technicians in Reno was she supervising, to your knowledge? Was Camilla Kim, for example?
Yeah, no, I've got the staffing and our pharmacies in Nevada are very small. They're like 4 pharmacists and 11 techs, both in Reno and in Las Vegas. So it's like 30 people total that work in Nevada, 15 in Reno.
So for 2 locations, 4 pharmacists and 11 techs?
4 pharmacists and 11 techs in each location, sir.
Oh, in each location. Okay.
Yes.
Okay.
Greg, can I ask one follow-up? Just because you said your term, but I just want to.
Yes.
So it's nothing new, but you said the pharmacist in Reno was doing the PV1, but the pharmacist in Kentucky was not doing the PV1. Just for the record, what's PV1? Because it's not in the law.
Pharmacist verification 1.
That means they're doing the data?
And that's only on new prescriptions.
What are they checking when they do a 1? What components? The right drug?
They're checking everything.
Okay.
Patient name.
What will go on the label?
Yes, sir.
Okay.
Yes.
You're saying PV1, but we don't know what PV1
I'm
is.
sorry.
So
I'm sorry. I thought it was a universal term. Forgive me.
no. Okay. Thanks, Greg.
So, Mr. Dean, why to your knowledge did PharMerica abandon this shared services model?
Yeah, as I mentioned to you, it was limited to the senior living. And we didn't get extreme value out of that. It was too limited in scope. So we abandoned that model.
So currently for the location, the pharmacy location on Longley Lane in Reno, who performs the data entry?
The technicians in Reno.
So, and the supervision occurs within the Reno location?
Yeah.
I don't have anything further.
Board members, questions for Mr. Dean? I'll start. I have a question. Did Camilla Kim, who is the Nevada pharmacist, have any supervisory responsibility for any of the Kentucky technicians that
No.
entered the prescriptions?
No.
And then there was mention of pick Renee Neargarden, I think, and then also pick Ashley Vest.
Yes.
Do you know which pick was working at the time of the misentry?
Yeah, Renee.
It was Renee.
Was.
And Renee at that time was licensed in Nevada?
Yes, ma'am. According to what I reviewed. Yes, ma'am.
Any other questions for Mr. Dean? Mr. Dean, where are you located?
I live in Virginia.
Virginia. Okay. I don't have any.
The accent, give it away. I live in the mountains, so it's a little Appalachian, so sorry about that.
No. All right. No further questions. Thank you.
Thank you for your time.
Any more witnesses?
Thank you.
Do you guys want to recess and then we'll do closing, or do you move to closing? Or-
Whatever the board's pleasure.
Let's go to closing.
Thank you, President Burke. I just, first I'd like to just cover the charges. So count one applies to respondent Camilla Kim only. Count two alleges assisting or permitting unlicensed practice. And that has been alleged against respondent PharMerica, as well as respondent Kim. Count three alleges unprofessional conduct by a pharmacy, and that charge relates to the kind of supervision of the pharmacy technicians, and the fact that this shared services model that they've explained does not comply with Nevada law in terms of supervision. And then count four, which I think I heard Ms. Biggs say they don't contest basically the misfill aspect of this count four, which is employer. It's alleged that the employer is responsible for the misfill by Camilla Kim. So I think that the dispute is over the question of whether this shared services model that they adopted with the Kentucky pharmacists satisfies Nevada law. And I would note that there's a statute on point. It is NRS 639-2328, and it allows, or it applies to non-resident pharmacies. So it allows a non-resident pharmacy to have a single person, a single pharmacist who is licensed in Nevada. That was adopted, I think in 2020. It was very recent. I think it was in 2025 that was adopted by the legislature. And I would like to emphasize that it applies only to licensing, right? It doesn't purport to relieve the pharmacy of any responsibilities related to the operation of pharmacy, supervision, quality assurance, those types of things, right? And I would also emphasize that it applies to non-resident pharmacies, not to resident pharmacies. Here we had a in-state pharmacy, PharMerica, located on Longley Lane, that was dispensing the drugs. So I think to suggest that they didn't have an obligation to comply with Nevada's supervision requirements because they had Kentucky people doing the data entry is not supported by the law. There's not a statute or regulation or legal provision, to my knowledge, that would relieve the Reno operation of the responsibility to comply with Nevada law, particularly as it relates to supervision. So think about Camilla Kim was in the pharmacy, and she was supposed to be managing pharmacy technicians in Kentucky. Well, the definition, our definition in Nevada, basically defines a pharmacy technician as someone who's directly supervised by a pharmacist. So there was no direct supervision occurring here. I would submit that Camilla Kim didn't have the opportunity to interact with these pharmacy techs. She did not have the ability to know their strengths and weaknesses. She had no ability to evaluate their performance, to evaluate whether they were diligent at times, whether they were lacking focus at times. I mean, all these things are very important. At least under Nevada law, we require the pharmacist to have some kind of direct interaction with the pharmacy techs who are performing any function that leads to the filling of a prescription. And data entry is one of those functions. Ultimately, data entry requires direct supervision by a pharmacist. And here, the resident pharmacy on Long Lane was not doing that. There was no supervision of pharmacy technicians. And we don't know, quite frankly, whether there was a violation of the tech ratio at the, but because there's no way to know at any point in time how many pharmacy technicians were kind of performing these tasks in Kentucky. But it certainly denied Camilla Kim the opportunity to kind of monitor that ratio. I mean, she had no practical ability to monitor that ratio to make sure that they were in compliance with that 3-to-1 tech ratio that we require in Nevada. So the system itself, just simply the shared services model and the way that they were filling these prescriptions by performing some tasks in Kentucky and some tasks in Reno simply does not comply with Nevada law. With respect to the kind of aiding or abetting unlicensed practice, I think I heard that the pharmacy techs were licensed in Kentucky, but because they were filling or assisting in the filling of prescriptions that were dispensed in Nevada by a resident pharmacy, they were essentially part and parcel of that Nevada operation, right? So PharMerica can call them independent contractors. They can kind of treat them whatever way they choose to. They can give them whatever label they want to. But the fact remains that the pharmacy technicians performing those functions should have been physically located in Nevada, which means they should have been licensed in Nevada. So that's the gist of the licensure argument. That's the gist of the count 2 argument. And then I've covered, I think, count 3. Regarding supervision, that's all that I'll have to say, and I may have some rebuttal in response to Meg's comments.
Thank you.
Thanks.
And as Mr. Zunino alluded to, counts 1 and count 2 as it pertains to Ms. Kim is not part of the proceedings for this particular presentation today. However, I want to take exception to a couple of the things that Mr. Zunino said, that especially that PharMerica was acting outside of compliance with Nevada law. PharMerica was acting exactly in compliance with Nevada law, specifically in regard to the shared services agreement, which your own regulations allow under NAC 639.921. There's a common ownership, there's a shared database, the prescriptions are then shared between the pharmacies. As far as the supervision piece, your own statute, NRS 6392328, says in part for a non-resident pharmacist, the non-resident pharmacy must provide the name of at least one registered pharmacist who practices at the pharmacy, who may be the managing pharmacist or another pharmacist, who will be responsible for any prescription dispensed to a patient located in Nevada and responsible for any acts or omissions of pharmacy personnel who are not registered with the board. Your own statute allows for that model. So for a pharmacist, a pharmacy, if they're acting in compliance with state statute and regulation, it's impossible to say that they're out of compliance. This law was enacted in 2023. This argument is a workaround for the compliance with that statute, that change to statute that the Nevada legislature said, yes, this is fine. Why PharMerica changed from the shared services agreement in Kentucky, frankly, is just simply not germane here. Camilla Kim had her responsibility in Reno. Renee Niergarten, and I can give you, she is license number 20412. She was licensed in this state as on November 20th, 2019, was the pick that was physically at the Kentucky location at the time that this prescription came in and had supervisory duties over the tech involved. PharMerica does take responsibility, vicarious liability for Camilla Kim not properly verifying prescription and catching the duration issue. PharMerica is totally willing and has been through the entirety of these proceedings to take responsibility. But to say that PharMerica is aiding and abetting in the unlicensed practice of pharmacy or is engaged in any other unprofessional conduct when they are acting in concise compliance with Nevada statute and regulation, I'm sorry, but that burden of proof has not been met in this case. And we would ask that the board find against PharMerica only as to count 4, which we agree that they are responsible for the fact that Dr. Kim missed the proper verification.
Thank you. Yes, Mr. Zanino.
Just to comment, 639-2328, NRS 639-2328, that authorizes, for example, a Kentucky pharmacy licensed as an out-of-state pharmacy to dispense drugs from Kentucky and ship them into Reno, to a patient in Reno. That it does authorize that, provided that there's a Nevada licensed pharmacist in that pharmacy. However, that does not authorize the Kentucky pharmacy and the Nevada pharmacy to join forces and pool their resources and perform some of the tasks in Kentucky and some of the tasks in Nevada. I mean, a Nevada licensed pharmacy dispenses drugs from the state of Nevada. And it simply must comply in all respects with Nevada law. 639-2328 does not relieve the Reno pharmacy or the Kentucky pharmacy from any other responsibilities other than licensure requirements. I mean, there's a licensure requirement in NE 328. However, that doesn't mean, for example, that the Kentucky pharmacy has no obligation to comply with operation standards. You know, the pharmacy tech ratio, for example, it doesn't mean, I mean, all of those things, provided that Kentucky chooses to dispense their drugs and ship them into the state of Nevada, they have to agree to comply with Nevada law. And that's one of the things that you vet the applicants on when they come in for a license. You ask them questions to ensure that they have a plan to comply with Nevada law. And that wasn't happening here. The Kentucky facility was not compliant because it wasn't shipping the drugs from Kentucky. It wasn't dispensing them from Kentucky. It took itself, outside of the operation of 639-2328 when they did that. I mean, the only law that applies is the law that applies to here to resident pharmacists and resident pharmacies, in-state pharmacies. And they simply weren't meeting the supervision requirements under Nevada law that apply to the Reno pharmacy.
Ms. Beggs.
Just briefly, the burden of proof lies on the board. There are no allegations that have been made or raised in the first amended accusation regarding Kentucky not complying with the ratios. That's not alleged. No facts have been provided by board counsel to support that allegation that is new to this. And I would submit to the board that this is exactly what I'm saying. Kentucky had a Nevada licensed pharmacist physically on site who is overseeing pharmacy techs. And there were Nevada licensed pharmacists and pharmacy techs in Nevada who were then filling that prescription. So this is a situation where, again, PharMerica has taken full responsibility for the fact that the error was not caught. However, we're not talking about unlicensed practice of pharmacy. We're talking about a Nevada registered pharmacist overseeing pharmacy techs who are doing sole data entry through a shared services agreement, which is allowed by the board's own regulation.
Thank you. All right, board members?
So just, you're gonna go to discussion or what's your?
Well, I was contemplating a break.
Okay, the break's
Take a break.
just remind everybody, we have a case going on. Nobody will talk to anybody. We'll keep separated, bathroom only, and then back to here.
Thank you. Quick break. All right, so we're back for our Board of Pharmacy meeting. And time for board deliberation. So for matter 5H, board members. Ms. Porath, would you like to start us off?
Sure. For the record, I think very clearly and undisputed are counts 1 and count 4 in this case. Clearly there was an error made and pharmacist Kim was ultimately responsible for the verification of that product before it left the Reno pharmacy, and that PharMerica is vicariously liable for her actions. In regards,
I'm so sorry, we're not doing count 1. This hearing is only on PharMerica, not Ms. Kim.
We'll do that next. That's fine. So just modify that.
I can't refer to count 4 without talking about count.
You were going down count 1. I just want to make sure that I just wanted to make the record clear. Thank you.
So I think where it is gray, what are acts of filling a prescription that constitute direct supervision? And so I'm just not, I'm undecided, I think, on this model. I think it would be ideally, in my mind, if you're gonna have technicians that are doing data entry in Kentucky, the PV1 step should probably be supervised by the Kentucky pharmacist before it goes to Reno. I think that would make things pretty clear. Things being as they were set up, I'm not really sure how to deal with that.
So I would agree. That's one of the questions that I was wondering, and now in retrospect, wish I asked Mr. Dean, is what did the pharmacists in Kentucky do if the pharmacist technicians were doing all the data entries and they're there, what was the role of the pharmacist? Because that part too would make more sense if they did the verification and then, since it was being entered there. So that part too is the model. I don't think it's a very a model that makes sense to me. Count 4, I think, again, everyone's on the same page, including the respondent. So I think that one's abundantly clear. Count 3. Did they engage employees in Kentucky to perform one or more of the functions necessary? That is true. PharMerica, they implemented a standard operating procedure. I'm just reading some of the allegations that required respondent Kim to remotely supervise employees So Mr. Dean says they did not have any supervisory authority over the techs in Kentucky. PharMerica had a duty to ensure that Kentucky employees were directly supervised by Nevada pharmacists. That did not happen. And respondent PharMerica had a duty to ensure that Kentucky employees were properly registered with the board to work as a pharmaceutical technician or techs in training. Oh, there's more. Go ahead.
That particular piece too, I guess I question because, we don't require technicians working in out-of-state pharmacy that fill prescription to be licensed in our state. They have to have a pharmacist that's licensed in Nevada to be able to, if they were shipping drugs into our state, we don't require every single technician that's working in an out-of-state pharmacy. So I don't necessarily think that particular statement is valid.
Okay, respondent PharMerica had a duty to ensure that Kim was not tasked with supervising more than 3 pharmaceutical technicians or 1 tech and 2 techs in training. So that may not be applicable through its conduct as described above. PharMerica performed 1 or more of the duties in an incompetent, unskillful, or negligent manner. So those are all the allegations in count 3.
I'm sorry, for clarification, do you still have a quorum?
We do. Thanks, Ann. Anna Carr is on Zoom. She'll be speaking here in a moment.
Thank you.
Thank you.
I just wanted to get.
You missed the beginning of the meeting. I said that we'll be monitoring it. There's going to be people moving all over the place. So we do though, but good point.
So any other, I guess, comments?
The only comment, Crystal Freitas, for the record, I would have is still an agreement with the both of you on count 3 being very unclear. Count 4 for sure, definitely. But there's a lot of questionable things in count 3 that I just can't say definitively.
Anna Carr, for the record. Oh, sorry, Adam. I just wanted to echo Crystal Freitas' sentiments on that last comment.
Yeah, Adam Pork again. I guess I would have a lot more heartburn if they were planning on continuing the centralized services model in the state of Nevada. I want to focus on the fact that an error occurred, there was harm to a patient, and that both the pharmacists and the company are responsible for that.
I agree. All right. So procedurally, do we make a motion about the complete findings of fact?
We do need, sorry, the senior Doug Todd Weiss for the record, we are gonna need separate votes on the findings of fact, conclusions of law. It may be easier in this case to start with the violation of law, then go back to the facts. Because some of the facts are not gonna be, depending on what the finding of the board is, some of the facts are not gonna be applicable for a finding, so we can't do a blanket finding of, facts 1 through whatever, like we could do sometimes. So I would start with the violation and then we'll backtrack and do a separate vote on the findings of fact.
Okay, so we'll start with the violations of law.
So can we start with count 4?
We could start with count 4. Yes, we can go out of order. Yes.
So I would argue count 4 to strike 61. I don't think it's contested that as alleged in count 1, responding to engage in non-professional conduct, and that his employer at the time of the violations that is responsible for the violations alleged in count 1. So I would just leave it at that.
So strike 61, just strike 61.
Strike
is that what you're saying?
61 and then the reference to count 2 in number 62. And any corresponding NRS to that, I would strike. Or NRS or NC, I guess.
Board members, any other comments? All right, did you want to make a motion?
Yeah, I would make a motion to find respondent Farm America guilty on count 4, amended to include to strike 61 and to strike reference to count 2 in line 62, along with the corresponding Nevada law references.
Anna Carr, second.
Okay, we have a motion by Mr. Porras, a second by Ms. Carr. Any further discussion? Okay, hearing none. All those in favor? Aye.
Aye.
Any opposed? Okay, that motion passes. And then in regards to count 3. I think we could do the same thing, Mr. Porath, in terms of striking some things out.
We go line by line.
We can go line by line. and That would actually be easier.
I would say line 53 is.
Agree.
I would say that line 54, which particular pharmacist was responsible to supervise the technicians in Kentucky, I think is unclear to me.
Okay. Right, so we could strike 54, 55.
I think the thing that's a little bit confusing in reference to our law is that it really has to do with an out-of-state pharmacy that is shipping drugs into our state. I don't think that Nevada law really contemplates this setup.
So Pharmaerica had a pick that was licensed in Nevada. Okay, we could come back to 55, 56.
56, I would strike.
I would strike as well. Okay. And then 57.
I don't know that we would know that based on how they were operating at that time.
We have evidence to be able to say that they were out of operation at the time of this event, so.
58. Fifty-eight would be applicable through 53. Potentially, we have a question mark in 55. 59. I think that with all the hesitation, we should strike 55. I'm sensing from the board that we're not comfortable with moving forward with 55. So with that, my recommendation would be to strike it then.
Well, but then what do we have left? Because 58, if that one only applies to 53. Yeah, it's not really this is Pharmaca engaged employees in Kentucky to perform one or more of the functions necessary to prepare a prescription or dispensing. Doesn't really state anything that they did that was unprofessional or not within the law. It just says that they engaged employees in Kentucky, which is true, but it doesn't say what they did against what's stated in law. For line 53 anyways. Because if we're striking everything else, all the stuff is what, 53, 58, and 59?
Yes. Senior DAG.
Senior DAG Todd Weiss, just a reminder to the board members, in order to find, on a find for a charge, there has to be, both the charge and the substantive underlying facts for that charge need to be proven by a preponderance of the evidence. So that's an important thing to remember. It's not just the charge, the underlying facts that support the charge also have to be proven to that standard.
So senior DAG, if we feel that that has not been met for count 3, is it found not guilty? Not guilty?
Senior DAG Todd Weiss, for the record, correct. If there's not enough substantive facts to support the conclusion that of the charge for count 3, then the finding should.
Thank you.
Does Anna have anything she wants to say? Put on record?
Board Member Carr, did you want to add any additional comments? I think we're near a decision.
I don't know, not in this matter.
Okay, great.
Thank you, though.
Okay, all right.
So, Crystal Fergus, I would move that we find respond or defendant for count 3 not guilty.
Second.
Okay, motion by Ms. Freitas, second by Mr. Pora. Any further discussion? All those in favor?
Aye.
Any opposed? Okay, that motion passes.
Senior DAG Todd Weiss, for the record. So before we get into discipline for count 4, the board now needs to go through the factual allegations of 1 through
27. Yeah,
Or
3 actual allegations,
sorry,
3
yeah.
to 27.
3 to 27 and determine which of those have not been met to the standards. Some of them are going to be applicable to the not guilty finding, I'm sure. We got to make sure that that is accurate. And then we will do a separate motion on findings of those facts that have been proven to the required standard.
Before we do that, do we need to address count 2?
Was my understanding that 1 and 2 were only applicable to the pharmacist?
2 is very amazing.
I think so. We've agreed, we've agreed in the stipulation to dismiss count 2 as it pertains to respondent Kim, right? So that I think you still have to make a finding as to whether there's, guilt or not guilt, not guilty on the part of PharMerica with respect to count 2. I don't know if you've done that yet or not.
No, not yet. No, so my apologies. I jumped the gun. So we got to go back to count 2 and figure that out before we do the facts.
Okay.
Adam Porter, my personal opinion on this is that we're gonna go through the same exercise and end up doing we did on count 3. I mean, I think that line 49 is true. Line 50 is I think questionable. And then that leads us into what basis do we have to stand on for the rest of sorry. So having said all of that, I would make a motion to find a respondent PharMerica and not guilty on count 2.
I would agree. Crystal Freitas, I second.
Okay, we have a motion by Mr. Porath, second by Ms. Freitas. Any further discussion? Okay, all those in favor? Aye.
Aye.
Opposed? Any opposed? Okay, the motion carries. All right, so now that we've done the violations of law, we'll go back to the factual allegations.
Todd, I think it's always better for me that when we're charging something, secondary to somebody other's action, that we get that in the record first. And since those factual allegations probably relate to count 1, can we move to count 1 and then come back to that to just make, I hate that if we go and say 4's, they're guilty of 4, which they're not really arguing, but we don't find them guilty on 1. I'm always concerned that how did we find them guilty on 4 when we didn't find them guilty on count 1?
This is Senior Dag Todd Weiss. I agree with you. The problem is the complaint is written as count 1 is only to pharmacist Kim. I believe. Am I correct on that?
Yeah, I think it is, because it's independent. I mean, it's 4 secondary. Lynn may agree to it or she may not, but I don't want you to get found guilty on 4 and then something happens on 1 and then 4 does, then we have a problem with 4. So
potentially we could table this for a moment, take the Kim matters and then come back to.
yeah, because I would like to find, if they do find Kim guilty of 1, then I think 4 would stand. But if they don't find Kim guilty of 1, then 4 can't stand, I don't think. So that
And the stipulation that we'd be presenting today,
we would just vacate that, right? Exactly.
will we have a stipulation to present to the board that would?
No, I mean, if 1's not found guilty, then there's no reason to do a stipulation. So I mean, you guys can figure it out. I always would go with 1 first, but that's not how you chose to do it. And so I just would warn you to not, we'll have to come back and deal with 4 if 1's not, if you don't agree with 1.
I mean, the suggestion is that you could adopt paragraphs 40 through 48 and restate those under count 4. If that's another.
I'll just leave it you to Todd to direct it. I think either way we get there, that makes me somewhat, I prefer to do the one first and then the.
Senior DAG Todd Weiss for the record. I mean, we could do this either way. We could take a pause, address the stipulation for pharmacist Kim, and then come back and adopt facts based on both of those findings that for count 4 as well as stipulation for pharmacist Kim.
Okay, let's do that. Then we'll transition to the,
Okay with that?
Yes, that's fine.
Okay, you're okay with that?
We could just take notice of the adoption, assuming it's adopted, we could take notice of that when we go back on the record or not.
Well, I'll be on the record the whole time, but when we get to that item, yes, I agree.
we'll move to the agenda items 5I and 5J.
And begs for the record on behalf of Dr. Kim, who's now present.
Mr. Zanino.
So, we have prepared a stipulation order for your, or proposed order for your consideration and possible adoption. This proposed order consolidates 2 cases, right? It consolidates case number 24-370 RPHN, which is the case that simultaneously involves PharMerica, where you just heard evidence on that. It consolidates that with another case number 26084 RPHN, which involves allegations of alcohol abuse by Camilla Kim in 2026, right? And so the purpose of the stipulation and proposed order is to consolidate those 2 cases and to resolve the allegations in both cases. So I'll note that if I can find that. So the notice, the first amended notice of intended action, accusation, whatever. The accusation begins on page 2379 in case number 24370. In case number 26084, the accusation begins at page 2379. These are agenda items 5I and 5J. The parties have reached a stipulation and proposed order that would resolve both of the cases that I mentioned simultaneously. I'll cover the key provisions beginning at paragraph 8. As to count 1 of the first amended accusation, and that's the accusation in case number 24370 RPHN. Respondent Kim does not contest the charge as alleged in that count and admits that the evidence exists and that the board could present such evidence in administrative hearing to establish the following. Between December 22 and March 24, PharMerica employed Respondent Kim to work as a pharmacist in Reno. Respondent PharMerica was under contract with Morningstar to dispense prescription medication and provide medication management services to residents of Morningstar in 2023 and 2024. Patient DP, an 87-year-old female residing at Morningstar, received medication and medication management services from Respondent PharMerica, including levothyroxine for hypothyroidism. Respondent PharMerica dispensed that to patient DP without interruption for a period between March of 2023 and March of 2024. However, on March 6, 2024, patient DP's physician issued another prescription for levothyroxine calling for a 90-day supply with 3 refills. The pharmacist, the non-pharmacist employee in Kentucky incorrectly entered a duration code. This was a maintenance medication. It stopped the auto refill function. The patient discovered that her mom had not been receiving the medication as prescribed. So as to count 1, respondent Kim acknowledges all of those facts. In paragraph 9, as to count 1 of the accusation, which is the case involving the allegations of alcohol abuse, respondent Kim does not contest the charge as alleged in count 1 of the accusation and admits that the evidence exists to establish a factual basis for the alleged violation. 1, respondent is a Nevada licensed pharmacist and the holder of registration number 19388. In February 2026, respondent worked as a pharmacist for PharMerica, which operates a pharmacy in Reno, Nevada. On 2 or more occasions in February 2026, respondent's coworkers observed that she appeared to be intoxicated or suffering from a hangover. On these occasions, respondent's coworkers observed that respondent was lethargic, unfocused, unable to perform her duties, and or smelling of alcohol. On March 1st, 2026, respondent's coworker observed that respondent once again appeared to be intoxicating or suffering from a hangover while on duty. The coworker reported that intoxication to a supervisor. At the request of the supervisor, respondent took a breathalyzer test, and that showed a BAC of 0.063. Which fell to 0.057, and then it subsequently fell to 0.036 over a period of just a short period of time. So in paragraph 10, this is specific to the alcohol related allegations. Respondent Kim acknowledges that she underwent a comprehensive physical and substance abuse evaluation by Dr. Mark Chase. Based upon the evaluation, Dr. Chase found that respondent Kim suffers from mild alcohol use disorder, a condition that is not indicative of chronic or entrenched pattern of disordered alcohol use. And that and I would note that Dr. Chase went into very detailed findings on that in his report. You don't have that, but Dr. Chase has opined that respondent Kim is psychologically fit to practice as a licensed pharmacist, provided that she participates in a formal professional monitoring program for a period of 2 years, and that she continues engagement with her current treatment providers. Respondent Kim has agreed at her own expense to participate in that professional monitoring program from June 1st, 2026 to June 30th, 2028. So therefore, in paragraph 11, to jointly resolve these 2 cases. Respondent Kim agrees to the following. Her certificate of registration number 19388 shall be revoked. However, the imposition of the revocation shall be stayed and she'll be placed on probation through June 30th of 2028. Upon successful completion of probation, her certificate of registration shall be automatically reinstated effective July 1, 2028 without conditions or restrictions. Respondent Kim agrees as a condition of probation to participate in the professional monitoring program that was referenced in paragraph 10 above. Respondent Kim further agrees that when her certificate of registration comes up for renewal in 2027, she'll appear if requested to answer questions concerning her progress and participation in the professional monitoring program. Respondent Kim agrees to pay a $1,000 fine payable on or before August 31st, 2026. Respondent Kim further agrees to pay costs of investigation and prosecution in the amount of $1,000 for case number 24370 and in the amount of $500 for case number 26084 for a total of $1,500. And during the term of probation, respondent Kim shall not engage in conduct that could result in disciplinary action pursuant to the Nevada Pharmacy Act. And as I mentioned this earlier, in the earlier proceeding, upon approval of the stipulation by the board, count 2 of the first amended accusation as the PharMerica case shall be dismissed as it pertains to respondent Kim. This constitutes a full settlement of the allegations in both cases, and the discipline will be reported to the National Practitioner Data Bank.
Okay, thank you. Ms. Beggs, any additional remarks?
No, all I would say though is Dr. Kim has been very compliant from the start. We did agree with Mr. Weiss when this came up that she would not practice until this matter was resolved. So she has not practiced since that time. She is no longer with Pharmaerica. I just wanted to let the board know that as well. But we would ask the board to accept this stipulation as presented today.
At least for the record, she was, I didn't find anything in I talked to her multiple times. I think even before Lynn was involved in the case, I didn't find anything in her behavior that would go against what Mr. Chase put in his report.
Board members, any questions on the stipulation and order?
Adam, for the record, I don't have a question on the stipulation, but I guess my question is if in the amended accusation, if there's pieces of count one that are, does that matter? Like if there are pieces of count one that may or may not be based on the evidence, we need to address those. Given it just, I mean, it's pretty generic in the stipulation. It just says that some evidence exists that say like an admission of guilt of all the pieces.
I see what you're saying. Senior Dag Todd Royce for the record. Yeah, I mean, that's tough because she's not admitting any specific facts in the stipulation. But we're being asked to make findings of those same facts in the complaint. Lynn, do you have any?
Well, working with Mr. Zanino on this stipulation, the wording of the admission as to the count one on the First Amendment complaint was the factual allegations to which he's admitting in the stipulation were discussed to purposely carve out that issue of the supervision piece because we knew that was going to be a contested piece today. So she's admitting to the facts that are set forth in the stipulation rather than count one as set forth in the First Amendment.
Well, and we just heard a full case on count one. That was the purpose of the testimony from Donna Fisher. So, I mean, you have a lot of evidence out there that directly pertains to the misfill. So, I'm struggling as to why you wouldn't be able to find that.
No, not at all. I guess specifically, if we're looking at the First Amendment action, it's 41, 42, 43. They're listed under count one that I think are of question based on the other. So
Senior Dag Todd Weiss for the record, I don't think we need to make findings on any of the counts under count one because those are applicable to Pharmaerica.
Okay.
So we can look at the paragraphs up until count one or what we need to make a separate vote on when we get back to the complaint. I know we got to deal with the stipulation that we're on first, but when we get back to the complaint for Pharmaerica, it's everything up to the paragraphs under count one.
Okay.
All right, so back to the stipulation in order.
Again, Adam, for the record, I'm comfortable with the stipulation.
I am too.
Crystal Freitas, I move to approve the stipulation and order as presented for Kim RPH.
Second.
A motion by Ms. Freitas, second by Mr. Porath. Any further discussion? Hearing none, all those in favor?
Aye.
Any opposed? Okay, that motion passes. Going back to Pharmaerica.
Your findings of fact?
Yes.
Thank you.
You have to go line by line ahead, keep everything.
Oh, there's a lot of lines.
Yeah, so we're starting on actual allegations. Number three.
Yes, so 3, 4.
3, 4, and 5 are true.
True, yep.
I think I would strike 6.
Yes, I agree. 6 is not.
Okay, so, and then 7. True.
True.
Is true.
Strike 9.
Okay. Number 10 is true.
Yeah.
Eleven, true. Okay, number 12. True.
True.
13.
True.
14.
I don't know, is that the dates? March 24th.
That's, I think that's true.
Okay.
Yes. 15. True. 16, true. 17, true. 18.
Strike.
Right.
Right. 19.
Five recent was fine.
Okay, so then I think 19 is true. 20 is true. 21, true. 22, true. 23, true. 24. True. 25. True. 26, true. And 27, true. So we're striking 6, 9, 18.
So moved.
Second.
Yeah, I want to make sure we get that a little bit clearer for the record, so we want to make the motion should be findings of fact, consistent with all the paragraphs up to, I don't know the numbers,
All
but,
the paragraphs with the exception of 6, 9, and 18.
well, it's not all the paragraphs,
Oh,
it's
sorry.
whatever up to, whatever the paragraph of right word count. So I think it's
So 3
3 through,
through 5, 6 through 8, 10 through 17, and then 19 through 27.
sounds good.
Worded that way. Okay. So was that motion made by Mr. Porak
Yes.
and then second by Ms. Freitas? Okay. All right, any further discussion? Yeah, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes.
Senior DAG Todd Weiss, and now we are on to discipline for the finding on count 4.
Do we, conclusions of law, lines 28 through 39, and we need to address those individually as well.
I think that was already, that was part of the vote on count 4. I'm sorry, wait, are you talking about kind of count 1?
There's references about supervision within those applicable laws, so I just need to.
Are you talking about 32? What number are you on?
I'm talking about.
The applicable laws?
paragraphs 28 through 39 before count 1.
You've not addressed those, but I'm not sure that Todd's gonna tell you you have to. You have you've released the other one, so you have a stipulation and then you have a conduit to number charge for count 4. I mean, you basically,
I
basically go to 39.
Yeah, I've done it. Yeah, you can recast applicable laws, conclusions to law, and then I'll walk you through and tell you which ones to omit. That aren't, and I think Lynn trusts me and she can monitor me if she thinks I'm getting out of line. And then you can recast count 1 as conclusions of law, certain of those, and you can strike others, and it's pretty simple. You know, if you like, I can walk you through that.
Sure. Thank you.
Okay. Conclude at paragraph 28, conclusion of law number 28 would remain. 29 would remain. 30 would remain. 31 is irrelevant. You can strike 31. 32 is irrelevant. You can strike 32. 33 is irrelevant. You can strike 33. 34 is irrelevant. You can strike 34. 35 is irrelevant. You can strike 35. 36 is irrelevant. You can strike 36. 37 is irrelevant. You can strike 37. 38 is irrelevant. You can strike 38. 39 is relevant. You should retain 39. And renumber all those accordingly. And then under count 1, again, I would recast this as a conclusion of law. You can strike 41 because it's just a restatement of the facts that you previously found. 41 is irrelevant. You can strike that. 42 is irrelevant. You can strike that. 43 is irrelevant. You can strike that. 44 is relevant. You should retain that. 45 is relevant. You should retain that. 46, you should retain that. 47, I would retain that. And 48, I would retain that.
Thank you.
I agree with this.
Great, thank you.
Worth move that we find applicable laws as outlined by board staff and amend count 1 to remove 41 through 43.
Okay, we have a motion. Do we have a second?
Crystal Freitas, I second.
Motion by Mr. Porras, second by Ms. Freitas. Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, that motion passes. Right, now on to discipline.
So if I may, I prepared a memorandum of costs in this case. And I'll ask, if you have it already.
Do you have it already, Lynn, or not?
Mr. Zunino did email it to
Do
me.
you have any concerns about it?
I do not.
You got it? Yeah. So the memorandum of costs itemizes expenses and fees totaling $2,732. I would note that we've allocated 1,000 of that to Camilla Kim. So the balance due from Pharmaerica would be $1,732.
Suggestion for a fine.
I do not. I'll defer to Director Weist.
Your choice.
He's got a recommendation.
A recommendation.
Adam, for the record, I think consistent with other cases like this, I would recommend a fine for Respondent for America of at least $1,000 in addition to the attorney's fees and costs of $1,732.
Discussion or motion?
It's my suggestion. Would you agree to 1,000?
I was just trying to think of the cases we did earlier today, which were also employer liability, and I think that is.
Feel somewhat that there are extenuating circumstances here and it should be a little higher, but I would be agreeable to the $1,000.
Anna, do you have any opinion?
Sorry, the sound is cutting out a little bit. So I think I heard it all, but so if I missed something or misspeak, I just want to apologize in advance. But I think that I would be agreeable to the 1,000, but I also agree that with Helen's statement that given some of the extenuating circumstances, I think a little more may be warranted, given some of the facts of this case.
So what were you guys thinking? What amount?
So I would be okay with a $1,500. I'm not looking at anything that's a lot higher. I just think it should be a little bit more based on some of the questions and the facts that we found in the case.
Anna Carr, for the record, I agree 1,500 sounds reasonable and fair.
Okay, I'll go ahead and make a motion. I would move that as form of punishment, we fine for America, Respond for America $1,500 due and payable 30 days from today, as well as attorney's fees and costs in the amount of $1,732 due and payable in 30 days.
We have to find the fees and costs reasonable, necessary, actually.
And then the fees for reasonable, the attorney's fees and costs for reasonable, necessary, and actually included.
Anna Carr, second.
Okay, we have a motion by Mr. Porath, second by Ms. Carr. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed?
We just didn't catch Anna. I think Noah's trying to vote, so.
Oh, no, I said aye. Sorry. I told I'm having trouble with my Zoom. I apologize.
We'll take a look at it at the next break.
Okay, all right, the motion passes. All right, thank you so much for your time. We'll take a quick break.
Good choice.
Take a quick break. All right, we'll continue with our next agenda item. I'm going to call for agenda item 6A for Kent Holtorf. Hi, good afternoon. If you could just state your full name for the record.
And then Alexander here on behalf of Dr. Holtor.
Great, and then I'll turn it over to Ms. Tucker.
Thank you. This is Laura Tucker, General Counsel for the Board of Pharmacy. We have an outstanding stipulation that has not yet been agreed to continue this hearing. I haven't received the signed stipulation back from Mr. Alexander, so right now the matter is not yet continued.
So I received the stipulation, I believe, on Monday. There were some changes that were made. I received it yesterday afternoon. I wasn't able to get in touch with Dr. Holtor. We don't have any particular objections to the stipulation, so we'd ask that the hearing regarding Dr. Holtor is continued as was our understanding.
Just a question for that. Thanks, Chandon. Are you agreeing to that stipulation or you just haven't got a hold of it? Because part of the stipulation was that admitting no guilt, that he would not practice any pharmacy practice. So I think that was the direction I got from President Park and Todd. So can we address that?
So the stipulation on that particular point is not a pending issue at all. We will be agreeing to the restriction that he's not prescribing in Nevada.
Or practicing pharmacy.
Or practicing pharmacy in Nevada, correct.
I'll leave it to Todd. I'm just trying to keep the record as clear as possible.
So I guess just to comment real quick. So I'm a little bit frustrated because all of this happened at the very last minute. I feel like there were clear instructions that we provided and then the deliverables didn't come through. Mr. Shandon, or Mr. Alexander, you're saying that you agree to the stipulation, but not all of it, or I don't understand why.
Amended, the initial stipulation had some issues in it. It was amended and it was sent back. Those particular issues were addressed. And it wasn't a concern, but I didn't receive it back until yesterday afternoon. And I wasn't able to get a hold of my client in time to get his signature.
Can I clarify? I actually sent it at 9:22 a.m. yesterday, so it was actually in the morning yesterday.
So
I made the attempts to, I think he's out of state of California. That's my understanding. So I wasn't able to.
Well, he's noticed for today. And my frustration is that, again, clear instructions were given. You're asking for a continuance. The continuance may be granted if you meet these conditions, and you're now telling me you're not able to do it in that, or you didn't do it in that time frame. So I take this very seriously. There's a care about the patients and, patient safety. And in this case, patient safety is in question. And so moving forward, I don't want this back and forth or these requests to go unanswered in a timely manner. This needs to be addressed in a timely manner. And I don't know if you're taking it as seriously as I would like you.
We're taking it very seriously.
Good.
We looked at the stipulation when it was sent over and asked for some changes, and we're taking it very seriously. That's why I can stipulate on the record as to the conditions that were agreed upon. And again, Dr. Holzhoff has no issue with not prescribing in Nevada and not practicing pharmacy in Nevada.
So I would propose we have it in front of you, you've got it now, so we can just read those conditions into the record. Either attorney can do it, and then we can agree to that. And then if they met what you told me to affect, then you can grant that continuation based off of those stipulated items.
Ms. Tucker.
Ms. Tucker wrote it, so I'm sure she'll read it. And I think you don't have to go through the whole thing, just what the conditions are.
Laura Tucker for the record. I will just, Mr. Alexander, I'll just read the paragraph 8 and the two conditions. So the stipulation states that pursuant to NAC 639.120 subsection 1 subsection A, the in-person hearing notice for June 3rd, 2026 in Las Vegas will be continued and re-noticed for a future mutually agreed upon regularly scheduled board meeting in Las Vegas, subject to the following conditions. A, Holtor shall not engage in any activity in Nevada for which a certificate, license, or permit is required by Chapter 453, Chapter 454, or Chapter 639 of the Nevada Revised Statutes, and B, no further continuance will be granted except as provided in NAC 639.120 subsection 1C.
We stipulate to those conditions.
And then the other point, just because we have the parties here, I mean, you set the agenda, so do you want to just set the agenda? Because the stipulation says in the future, we'll put it wherever you want to put it. Our next meeting's in July, and we have one in Reno after that, and it's then back into Las Vegas. So if you want to just set that, for the calendar, then July's already set, but we'll do whatever you tell us to do.
I would like this matter to be heard on July 15th.
Okay.
Only concern with that is that we've got, I think, 6 experts and we do have to coordinate with those experts. I
You've-
want to attest to something.
That was your argument before.
Correct.
You cannot, like this, there has to be a point in which this case is heard, so it needs to be on July 15th. So I would recommend that you have your witnesses lined up before that.
And to be clear, just for the right, you're not stipulating to it. So I mean, you can, after this, you can take whatever legal remedy that you want to take. You're stipulating to you won't practice pharmacy in Nevada. So you're not stipulating to that date. She's just setting the calendar so that we don't have this discussion offline. It's here. She sets the calendar, she'll set it, and then we'll proceed with that date.
My only concern with that is, like I said, there was a stipulation about no further continuances. So if we're setting a date, my understanding of the discussion was that the date would be mutually agreeable by the parties.
Well, we never got the stipulation done, and we stipulated to what we stipulated to, and it really is Helen's decision for the scheduling. So if you want to talk to her, you can talk to her about that.
Again, that would be my only concern, is that I'm stipulating to something without knowing availability of witnesses. It's an out-of-state case.
But just again, Dave, for the record, you're not stipulating to the date. You're not stipulating to the date because she's setting the date. You guys didn't agree to a date and she's setting the date.
So the date is set, and we've stipulated to no further continuances. It's sort of set in stone, as I understand.
So I mean, Mr. Weiss can give me some additional advice, but again, I think this comes down to patient safety. You've already asked for a continuance because you have witnesses that you want to bring in. You have early notice, earlier than anyone else, for July 15th. I feel like that's sufficient amount of time to get your witnesses in order.
This is Senior Todd Weiss. I wouldn't read that stipulation as saying that you can't apply for another continuance if due cause is there, but I think the president's telling you that witness availability is going to be a tough argument for good cause at this point, given the continuance is being granted now. Six witnesses is a lot to ever get coordinated to be available on one day. I mean, I understand that, but so I see what you can do, and you can always petition for something if need be, but it's going to ultimately come down to the president's discretion on that.
So that closes, does that close that item, or we're going to deal with a dismissal of it? The dismissal is going to be continued. We're agreeing to that. Okay, I just want to make sure for the record we have.
Appreciate that, Mr. Reese.
Okay.
Right, then we'll move to agenda item 6C.
Just to be clear for the public, this is a completely unrelated item to the other item. So
This is for Prime Plus Lakeview Pharmacy. Okay, I'll turn it to Ms. Tucker.
Laura Tucker for the record. This is case number 25-110-B-O, Board of Pharmacy versus Prime Plus Lakeview. It can be found in your board book starting on page 2947. Just to give a brief background of what this case is about, this is a citation and fine appeal that was filed by Prime Plus Lakeview to appeal a citation that was sent to them on September 15th, 2025. Prime Plus Lakeview appealed this on October 15th, 2025. And the citation generally alleged that Prime Plus Lakeview sold and or shipped prescription drugs to First Choice Pharmacy in Las Vegas without a wholesaling license, so without having a license to do so with the board. So that's the general facts of the case, and I'll turn it over to you, President.
I will turn it to Mr. Alexander for any comments or remarks.
No comments about the procedural history, other than there was a motion to dismiss that was filed, so I would just ask how the board wants to entertain that motion before the hearing begins.
Senior DAC Todd Weiss for the record. We should deal with the motion dismissed before getting into the substantive hearing. My recommendation would be start with oral argument from the sides, and then we'll go from there. This is a decision to be made by the president alone. So that's my advice on that.
And who starts, Todd?
Whoever made the motion, so that would be Mr. Alexander.
And then, Mr. Alexander, if I could just ask you to speak closer into the mic. Thank you.
So thank you, Madam Chairperson. This is Chandon Alexander of Spartacus Law Firm here on behalf of respondent Prime Plus Lakeview. So we have a pending motion to dismiss in this case because if there is nothing, if the motion is granted, there's nothing left to try. So at the outset, the standard is that it's a board standard. In its opposition, the petitioner cites Simpson versus Mars for the proposition that a charge should be dismissed before hearing only if the petitioner can prove no set of facts that would support it. This petitioner also cites two other cases. We agree with both of those cases. And applying that standard, the citation must be dismissed because even if every factual allegation in the amended statement is taken as true, it doesn't establish a violation of law. This entire case rests on a certain premise. The premise is that Prime Plus Pharmacy is a wholesaler that engaged in wholesale distribution into Nevada. Every authority in the amended statement, NRS 639.100, NRS 639.233, NAC 639.593, and the cited federal provisions applies only to a wholesaler engaged in wholesale distribution. This case involves a single prescription through a wholesale marketing platform called RxRead one time in 2023, and there were no prescriptions ever before then or after then into the state of Nevada. That simply doesn't equate to wholesale distribution. And even if it arguably did, NRS 631.0155 defines wholesale distribution and it carves out the conduct here. The statute excludes the sale or purchase of a drug for an emergency medical reason, the sale or purchase of a drug pursuant to a prescription, and a transfer not exceeding 5% of the total annual sales by one retail pharmacy to another. So what we have here is one sealed bottle, one date, one buyer between two licensed retail pharmacies. And if we look at the document that's attached to the motion in Exhibit A, the invoice reads on its face that the buyer attests that this item is for a specific patient need pursuant to a prescription. The exclusion is unqualified and it reaches the sale, not just the dispensing event. That means that the provision in the carve-out exception in NRS 639.0155, would apply. Even setting the exclusion aside, the citation fails for independent reasons that require no evidence at all. That's why I said the citation can be dismissed on its face. NRS 639.323 and NRS 639.100 require a license only of a person who engages in business of wholesale distribution. That phrase, the business of, is highly relevant. Denotes ongoing regular commercial activity. This again was a single one-time transaction. And a single one-time transaction is all the amended statement even alleges. One date, one buyer, $1,200 sale. The statement pleads no pattern, there's no course of dealing, there's no regularity. In fact, it pleads the opposite. As a matter of law, you can't infer that a pharmacy is engaged in business of wholesale distribution from one isolated sale and event. The inference is just not supported here. And so therefore, we feel strongly that just looking at the face of the complaint, the allegation that Prime Pharmacy engaged in wholesale sales as a result of one single transaction fails on its face. It's not a business activity. And even if it was, there are carve-outs in NRS 639.0155 that allow for the sale based upon a specific patient need It also allows for a sale in cases of where the sale doesn't exceed 5% of the total revenue of the pharmacy. And in this case, this amount is $1,200. So that would mean that the pharmacy would only, or would be limited to $24,000 in total sales, which I think this body could take, or the president could take judicial notice of, this number that's very, very low and not typical of pharmacy revenue.
All right, Ms. Tucker?
For the record. I ask that the respondent's motion to dismiss should be stricken or denied because it is procedurally improper without merit. Each of the arguments that respondent is making are related to they are related to arguments that should be more properly made during hearing. This includes the whether or not the pharmacy is qualifies under one of the exceptions. It includes whether a single transaction applies to be a violation. And it also includes whether the sale took place at all. The respondent attached an exhibit to the motion to dismiss, which is actually one of the exhibits that the board intended to bring during the hearing as evidence to support the argument that the motion should be dismissed. But you have to consider only the accusation on its face. Furthermore, the respondent's request for the motion to dismiss is procedurally improper because the respondent is the one who requested this appeal in the first place. So he first asks for the appeal and then he asks you to dismiss it before hearing the case. Additionally, we have provided the respondent with a short and plain statement of the matters asserted in the 233B statement that was sent over, asserting the unlicensed wholesaling in Nevada. Therefore, we have met the requirements needed to present a case in front. And for the following, and for those reasons, I ask that the board either strike or deny the motion to dismiss.
Can I respond to that briefly?
You can respond.
So just on the issue of asking for a motion to dismiss in a hearing request, we haven't withdrawn the hearing request. We're asking you, Madam President, to resolve a threshold legal question first. Whether this charge states a violation is a matter of law. We're arguing that it doesn't, because there's no way that a single isolated transaction that occurred almost 3 years ago can qualify as wholesale. So there isn't a wholesale license that's needed. The petitioner's own authority says the board options on a citation are to uphold it or dismiss it or set it for hearing. So it doesn't preclude us because we file a responsive motion. Motions are filed in all the time. Just had a discussion about a motion to continue. So it's not improper to file a motion to dismiss. Again, I don't believe that the petitioner in this case addressed the fundamental issues. Single isolated transactions from an out-of-state pharmacy cannot qualify as wholesale. And that's our position. And there's nothing in the first amended statement that proves that there was any wholesaling involved in this case. And therefore, on its face, the first amended statement should fail.
Can I ask one question? Just, it's okay. So, thank you, Mr. Axel. You're saying it's a pharmacy, and I just want to, for the record, or is it a licensed pharmacy in Nevada, or it's licensed in a different state? That what the entity?
Prime Pharmacy is licensed in Illinois.
Okay, but it's not licensed in Nevada.
That is correct.
I just want to make sure that for the record.
And then I'll give Ms. Tucker an opportunity to respond.
The fact remains that it is the duty of the board to either uphold or dismiss the citation. And the point of this hearing is for the board to make a decision and to look at the evidence, give both parties an opportunity to present their evidence that supports their position. And so therefore, having the hearing would be appropriate in this case.
Thank you.
Senior DAG Todd Weiss, for the record. So when we're looking at a motion to dismiss at this stage of the proceedings, and the standard, as was stated by Mr. Alexander, is if the charging document fails to state facts, which if taken as true would form a sufficient basis for discipline, that comes not only out of the board's regs, but also NRS 622A360. That is an allowable pre-hearing motion. I believe that is what is in front of you, Madam President. The four corners of the complaint, well, sorry, of the citation in this matter, need to state a proper basis for the action. If the facts are taken as true, if you are forced to weigh the truth or untruth of facts, if you are required to accept or take into account outside evidence that at this point has not been admitted into this matter, those are not what you were to weigh when figuring the motion to dismiss. So everything that you will need to decide on this motion is in the four corners of the citation.
So I think in terms of the factual allegations that are listed, there's enough listed to warrant more information, or I have more questions, or to get a hearing for the case. I think it qualifies, despite it, the argument of it being just one case. I think that it means it happened. So I deny the motion to dismiss the case.
Okay, so we'll move into the case.
Move into the case.
So Laura will do opening statement. Is that right, Todd?
Correct. Do we have any other pre-hearing motions beyond the motion to dismiss?
There are some pre-hearing motions, but I'm gonna waive those unless they're raised as issues, there's some evidentiary issues, so I'm gonna just keep that in reserve.
Fair enough. Then we can move to opening statements.
Laura Tucker for the record. This case is an appeal of a citation that was sent to Prime Plus Lakeview for unlicensed wholesaling activity in the state of Nevada. The board alleges that in August 2023, Prime Plus Lakeview sold and/or shipped prescription drugs to First Choice Pharmacy in Las Vegas, despite not having a license to do so with the board. Prime Plus Lakeview does not hold a wholesaling license. It does not hold a pharmacy license in Nevada. As a result of the sale, the board sent a citation for Prime Plus Lakeview for $5,000 for engaging in unlicensed practice in violation of NAC 639.593 and NRS 639.233. We intend to show that this transaction was a sale from one pharmacy that was not licensed in Nevada to a pharmacy that was licensed in Nevada, which is defined as wholesaling activity in the state of Nevada. Prime Plus Lakeview, as stated, did not have a license to engage in this activity in Nevada, and therefore the citation was proper, and we will ask the board to uphold the citation. Thank you.
Mr. Alexander?
So you've already heard a bit of our legal position on the motion to dismiss, so I won't retread it, but I'll just tell you instead what the evidence in this hearing will and will not show, because the burden belongs to petitioner, and petitioner's own evidence won't carry it. This case is about a single prescription, not drugs, but a drug, a non-controlled drug, sold one time on one day to one pharmacy. That's the whole transaction. The evidence isn't going to show a second sale, no pattern, no course of dealing, nothing that makes Prime Pharmacy a wholesaler that would have required them to get a license. And in fact, in NRS 639.0155, there's certain carve-outs that allow for transfer of a drug. And it's in section 3, it's for emergency medical reasons pursuant to a prescription, transfer of drugs in an amount not to exceed 5% of the total amounts of sales by a retail pharmacy to another retail pharmacy to alleviate temporary shortage. If you look at the invoice that I presume that the petitioner is going to introduce in this case, it says specifically in the invoice that there was a specific patient need. So this wasn't a random sale. It was based on a specific patient need. And that in itself doesn't qualify as wholesale distribution. So as you're aware, the petitioner carries a burden of proof by preponderance of the evidence, and we believe when this hearing closes, the petitioner will not have shown and cannot show, based upon this singular transaction, that Prime Plus engaged in the business of wholesale distribution, because it did not engage in the business of wholesale distribution. Its own evidence that comes from the petitioner is just a single patient need transfer. So we ask that you will find that the petitioner won't have met its burden and to impose no discipline and dismiss the citation that was issued.
Thank you. Right, Ms. Tucker?
I'd like to call as my witness investigator Dina McClish from the Board of Pharmacy.
Dina, if you could state your full name for the record.
Dina McClish.
Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Thank you.
Excuse me, Laura Tucker for the record. I didn't say that last time. Investigator McClish, can you tell me your title with the Board of Pharmacy?
I'm an investigator with board.
And can you just briefly describe what your role is? Or sorry, your job description?
I generally investigate complaints which are received from many different avenues.
And were you the investigator for the case at issue, case number 25-110?
Yes, I was.
Can you tell the board what you were investigating?
So during an inspection, our inspector found a bunch of invoices, mainly which stem from RxE. And there were a lot of sales of prescription drugs from pharmacies or entities that were not licensed in Nevada.
And what pharmacy did the inspection take place at?
First Choice.
Was Prime Plus Lakeview one of the pharmacies that was identified from these invoices?
Yes, it was.
And can you recall about how many pharmacies were involved in this investigation?
There were quite a few. I can't recall for sure, but I want to say around 30.
And can you briefly tell the board, you mentioned the RxE. Can you briefly tell the board what RxE is?
RxE is like an online platform that's used to kind of essentially broker these sales.
And can you tell me what the outcome of your investigation was as to all of the pharmacies that you were investigating?
So some were licensed in Nevada, some were not.
And specifically, what was the outcome of the investigation as it relates to Prime Plus Lakeview?
So Prime Plus Lakeview held no registrations with the Nevada Board of Pharmacy.
I am going to have Mike pass out to the board what I am marking as proposed exhibit 1, and then you could also give one to Mr. Alexander and also to investigator.
Are you admitting it?
Not yet. I have
Okay.
to.
I don't hand it out to the board members yet till they feel Helen rules on it. Sorry. Just the technicality.
Or if it's an invoice, also.
Okay. Yes, this is the invoice.
So we stipulate.
Okay. So it's just for the record,
No, you
Mr.
can't.
Alexander. Mr. Alexander is stipulating to the addition of this exhibit, which is,
So- We'll admit as exhibit 1.
thank you, Mr. Alexander. Investigator McClish, do you have a copy in front of you?
I do.
Do you recognize this document?
I do.
How do you recognize this document?
This is one of the invoices that was provided to me as part of the investigation.
And what specifically is it an invoice of?
It is an invoice of the sale of a prescription drug, Vemlidy.
And is this a true and accurate copy of the invoice that you reviewed during the course of the investigation?
Yes, it is.
Investigator McClish, I'm just going to have you walk through the document and identify a couple of items for the board. Can you identify for the board who the buyer is on the invoice?
The buyer is First Choice Pharmacy here in Las Vegas.
Okay, and can you identify who the seller is?
The seller is Prime Plus Lakeview in Chicago, Illinois.
Can you also identify the drug that is listed on the invoice?
Vemlidy oral tablet, 25 milligrams.
And do you know what Vemlidy is?
It's a prescription drug, I believe, for hepatitis B.
And can you tell us what the date of the invoice is?
So it looks like it was received here in Las Vegas on September 1st of 2023. But the transaction date on the bottom that is from the seller is August 25th of 2023.
So Investigator McClish, do you, as part of your investigation, did you conduct any licensing searches on the seller that's listed on the invoice?
Yes, I did. Yeah, I did an inquiry in our online database system for Nevada and found that Prime Plus Lakeview did not have any registrations or licenses with the Board of Pharmacy.
Just want to break that down a little bit. So did Prime Plus Lakeview hold a license in Nevada as a wholesaler? During, just to confirm, did Prime Plus Lakeview hold a license in Nevada as a wholesaler in August of 2023?
No, they did not.
Did Prime Plus Lakeview hold a license as a wholesaler in Nevada during any point from then until you conducted the search?
No, they did not.
Did Prime Plus Lakeview hold a license as a pharmacy in August 2023 in Nevada?
No, they did not.
And during your search, has Prime Plus Lakeview ever held a license as a pharmacy in Nevada from that time until you conducted your search?
No, I did not find they'd ever held any registrations or licenses with our board.
So just to confirm, has Prime Plus Lakeview ever held any licenses to practice in Nevada by the Board of Pharmacy?
No.
I don't have any more questions at this time for you, Investigator McClish.
Mr. Alexander?
Sure. So Prime Plus Lakeview is a licensed retail pharmacy, correct? They are licensed.
They're licensed in Illinois, they're not licensed in Nevada.
Right. And First Choice Pharmacy is a retail pharmacy licensed by this board located in Nevada.
They are licensed in Nevada, yes.
So it's fair to say that the transaction was between two licensed pharmacies, correct?
Well, licensed in their respective states, yes, not both licensed in Nevada, no.
And the drug at issue, Vemlidy, it's not a controlled substance, correct?
No, it's a dangerous drug. Still a prescription drug.
And during your investigation, you identified only one transaction between Prime Plus and any Nevada pharmacy, is that correct?
I believe so.
And it's just this one bottle on this date with this buyer, correct?
Correct.
And you didn't find any shipment from Prime Plus into Nevada before August 2023, correct?
During my investigation, no, I did not.
Did you ever look after August 2023 up until the current date?
I don't believe so, but I'm honestly not sure. I'd have to look at my records.
Would it be fair to say that there probably is no record of any subsequent shipments of drugs from
Most
Prime
likely,
Plus?
but I can't attest to that.
So just for the record, you have no evidence that Prime Plus ever sold to any other Nevada pharmacy, correct?
Correct.
Is it fair to say that there wasn't any repeated or ongoing course of dealing by Prime Plus Pharmacy into Nevada?
Not to my knowledge.
And there was no evidence that Prime Plus operates a warehouse or has a warehouse of drugs or anything like that?
I have no idea. I didn't visit their facility.
During your investigation, did you ever uncover that Prime Plus holds itself out to anyone as a wholesaler?
Again, their pharmacy license in Illinois is.
So we introduced one exhibit, that's the RXC invoice. That was exhibit 1, is that correct?
Correct.
I'll just ask you to read, just to make it easier, because it's very hard to read, just the highlighted portion of that invoice.
Buyer attests that items are for a specific patient need.
And you have no document that contradicts that statement, is that correct?
No. Sorry, no, I do not have any document.
And no evidence that this transfers any purpose other than just filling a patient's prescription on that specific need, correct?
I have no idea what it was for.
I'm sure you probably don't, but do you know Prime Plus's total annual sales?
I have no idea.
Is it fair to say during your course as an investigator, 24,000 would be an extraordinarily low number for a gross revenue of a pharmacy?
I mean, it widely varies what the gross revenues are, so it wouldn't surprise me in some that I've seen, but on average, no.
You don't believe that's a low number?
I've never been to any pharmacy in Illinois, sir, so I couldn't attest to anything that their gross revenue sales are.
How about Nevada?
It would be rare.
It would typically be a lot more, correct?
Correct.
And no patient was harmed from this transaction to your knowledge, is that correct?
Not to my knowledge.
Are you aware that if the Nevada Board of Pharmacy received any complaint from any patient about this transaction?
Not from a patient, no.
If there was a patient that complained, you would probably be aware of that, is that fair?
We would most likely be aware, but there was a complaint, it just wasn't a patient.
And just for the record, there's no evidence that the product was adulterated, improper, that there was something wrong with the prescription, is that correct?
I never physically viewed the product, so to my knowledge, no.
So as to your investigation, the documents that confirm this transaction are essentially just the RX Read invoice, is that correct?
Correct.
Did you ever interview anyone at Prime Plus?
I did not, but I don't know if they were one, there were many I ran into that had been closed since, and I don't know if Prime Plus was one of those or if they were still open at the time. I did send out inquiries to every pharmacy, but I don't recall offhand. I would have to go back and check my records if they ever responded to that inquiry.
But did you actually interview anyone from Prime Plus?
No.
And you didn't review any records regarding Prime Plus and their business records beyond what is there in that invoice, is that correct?
I would have asked them for an original invoice for this drug. I don't recall, again, I'd have to go back and look at my records to see if they provided it or not.
So essentially, it's fair to say that the conclusion that Prime Plus was engaged in the business of wholesale distribution rests on that single invoice, is that correct?
Correct.
That's all I rest.
Board members, any questions for Ms. McClish?
I also, President Park, have a couple of.
I'm sorry.
I'm not sure.
Yes. No, go ahead, Ms. Tucker.
Okay. Attorney General, Laura Tucker, General Counsel for the record. So Investigator McClish, you had mentioned during direct examination that you looked into a number of pharmacies, is that correct?
Correct.
When you were looking at the other pharmacies, other than Prime Plus Lakeview, how many transactions did those pharmacies usually have with the Nevada-based pharmacies?
I'm gonna object because it's not relevant and it's assuming facts not into evidence. We have no evidence of any other pharmacies or transactions from any other pharmacies in this case.
I mean, I would say that it's relevant because Mr. Alexander is arguing that one transaction is not enough.
So I would agree. So your objection is overruled.
There were many that only had one transaction. There were many that had two, maybe three.
And to your knowledge, did the board send out citations based upon these other transactions that other pharmacies made?
Yeah, they sent out a similar citation to every unlicensed.
Any other questions, Ms. Tucker?
No further questions.
Mr. Alexander?
No further question. No other.
All right, thank you. Board members? Thank you, Ms. McClish. Ms. Tucker?
I have no further witnesses to present, so I'll just.
Okay, thank you. I'll turn it to Mr. Alexander.
We don't have any witnesses in this case.
Then we'll move to closing.
Sorry, I wasn't expecting that, so.
Or board members, any questions before we move to closing? All right, go to closing.
In this case, the citation alleges that Prime Plus Lakeview engaged in unlicensed wholesaling in violation of Nevada law. We have shown that Prime Plus Lakeview did not hold a license in Nevada to wholesale or to practice pharmacy in Nevada. In August of 2023, Prime Plus Lakeview sold a prescription drug to First Choice Pharmacy, a licensed pharmacy in Nevada. At the time of the sale, Prime Plus Lakeview did not hold a certificate of registration as a licensed wholesaler under NRS 639.233 or NAC 639.593. Furthermore, Prime Plus Lakeview did not fall under any of the exceptions. There was no emergency or temporary shortage of Vemlidy at the time of the sale. And additionally, NRS 639.0155 subsection 3, when read in the plain language, was added to, it was originally added to confirm that licensed pharmacies that were filling a prescription do not also have to obtain a wholesaler license in Nevada. This activity describes a retail pharmacy situation. It doesn't contemplate a transaction involving three parties or a wholesaler situation. That was not the case here. Here, Prime Plus Lakeview sold a prescription drug to a pharmacy in Nevada. For this activity, Prime Plus Lakeview should have obtained a license to wholesale in Nevada from the board. As such, Prime Plus Lakeview acted as a wholesaler in Nevada without the proper licensure in violation of Nevada law. Under its proper authority, the board issued a citation to Prime Plus Lakeview pursuant to NRS 639.2895, subsection 2 for unlicensed activity in Nevada. And therefore, we respectfully ask that the board uphold the citation for unlicensed practice for $5,000.
Mr. Alexander?
So the burden in this hearing, as we talked about, belongs to the petition, the standards preponderance of the evidence. To discipline Prime Plus, the board had to prove it's more likely than not that Prime Plus engaged in the business of wholesale distribution into Nevada. To carry that burden, the board offered one witness, one document. So I'd ask you to do something as you deliberate. Hold the board to what its witnesses said and what its own document says. Because when you do, you'll see the board didn't just fail to prove wholesale distribution. Its own evidence proves the opposite. The investigator was forthright. She told you that this was one transaction, one time with one buyer, no other sale by Prime Plus into Nevada, none before, none after. She told you that nothing contradicts what the invoice says. And so this is the board's case, a single sale, and an investigator who candidly admitted there was nothing more. The law the board charge requires more than one sale. That's very relevant. NRS 639.233 and NRS 639.100 require a license only of a person who engages in the business of wholesale distribution. So as the petitioner's talking about, they needed a license, they would necessarily have to be a wholesaler. Doesn't follow that a single prescription fits that bill. And in fact, if you look at, and we talked about that particular statute, NRS 639.0155, there's a carve out. The carve out allows for the sale of a transfer of drugs for emergency medical reasons pursuant to a prescription, a transfer of drugs in an amount not to exceed 5% of the total amount of sales by a retail pharmacy to another retail pharmacy to alleviate a temporary shortage. What you see in the invoice also is there's a specific patient need. We don't know if there was a temporary shortage, if there was some type of emergent situation that caused First Choice to reach out to RX Read and get this prescription. I think also, just to discuss what happened in another hearing today, I believe a board member said, the law is not clear about this. And I would agree with that. The law is not clear about this type of transaction, but what is clear is that a single transaction can't equate to wholesale. So the board is asking you to say that a single event constitutes a business or a business transaction. I don't believe you can reasonably draw that inference because there's nothing to draw it from. A bottle, one sale of a prescription medication for a specific patient need is not a business. And that failure decides this case because everything the board charged hangs from it. If Prime Plus wasn't engaged in the business of wholesale distribution, then it's not a wholesale. And so ultimately, the board would have to conclude that an out-of-state licensed pharmacy selling a prescription medication to another pharmacy licensed in Nevada for a specific patient need would constitute wholesaling and would necessarily require a wholesaler's license. And that sets, I think, a very dangerous precedent if in fact there is a medicine that is necessary for a patient. So we're here today to protect the public from harm. But what if there is a significant medication that's available only in California? And that's what the statute, the carve-out addresses, 639.0155. That's what I'm saying here. It's clear from the invoice, there was a specific patient need. It wasn't just a random sale. And therefore, it is permissible and it's not wholesale activity, especially since there was no activity before, no activity to date. So it wasn't as if Prime Plus was out on a new business endeavor. But again, to restrict this type of activity for a singular sale puts the public at harm in case there's ever a medication and a shortage that a patient needs and we have it in another state. The answer then would have to be no, because they would have to have a wholesaling license, which is a process in and of itself. So I'll rest.
Thank you. Okay, I'll turn it over to our board for deliberation.
I feel like I'm talking a lot today. Adam
We
Port-
all are. There's only 4 of us. So.
Adam Ports for the record. I think my opinion on this is that the exemptions in NRS 639.0155 talk about transfer drugs between a retail pharmacy to a retail pharmacy, specifically to alleviate a temporary shortage. I don't think there's been any evidence presented today to suggest that there was any sort of a shortage situation going on. Also, I don't think that Prime Plus Lakeview meets the definition of a retail pharmacy because they were not licensed in our state. So I don't think that they meet that exemption. I also don't buy the argument of one sale does not constitute wholesaling. Within our organization, we hold a wholesaler license at one of our pharmacies, and we don't even sell anything. We're distributing drugs without a sale, so $0 invoice. But because we're doing that outside of our common ownership, that license is necessary. So for all of those reasons, I think that the second fight should stand.
I agree. My notes are similar, that the arguments do not meet any of the exceptions, that there was no shortage, that a prescription drug was sold to a pharmacy in Nevada. I think the facts are pretty clear in this case that Prime Plus Lakeview is not licensed in Nevada. And I disagree with the counselor's argument that it puts patients at harm if we uphold this, because it puts patients at harm when wholesalers or pharmacies or licensees or people who don't do those things, who don't properly register with the state that they're doing business with. I think that potentially puts patients at harm, or does put patients at harm. So with that, I would also agree that we should uphold the citation.
The only other additional statement I would say, other than what's been said, is I don't believe that this was based on an emergent need. If you look at the date it was shipped, it was 8/25/2023, and it wasn't received till a week later, so that doesn't constitute an emergency in my mind either. So even if it was a retail licensed pharmacy in the state of Nevada selling to another's licensed pharmacy in the state of Nevada, that emergency is usually quicker than 7 days.
Board Member Carr, did you want to add any comments?
Hi, yes, Anna Carr for the record. I'm in complete agreement. I feel like this needs to be upheld because of the risk to patient harm and the lack of the emergency status.
Okay. So I think we're ready for a motion. This is Helen Park. I'll make a motion to uphold the citation.
Adam Brookside.
Okay, any further discussion? Okay, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion carries. Thank you for your time. All right, I think that completes
We have one more activity.
one left, and that is public comment. All right, so we'll open up the period for public comment. If you wish to make a public comment, please come forward. If you are online and you wish to make a public comment, please raise your hand in Zoom or press *6 or *9 to raise your hand and to have your line unmuted. Okay, do we have anyone who wishes to make a public comment? Don't see anyone in the room. Do we have anyone online?
Anybody online, Madam President?
With that, we'll go ahead and adjourn the meeting for today. We'll reconvene tomorrow morning at 9 a.m. Thank you, everyone.